marriage prospects also.
No, it is Mr. Shastri, even
Yes,
as per the evidence of PW3, the neurosurgeon, it is not that he had lost total capacity to...
Yes, I do admit.
You have not heard me and you are agreeing. He has lost, he did not lose the total capacity to remember anything. He has that period specific loss of memory. That is when he lapsed into coma and recovered. So that period memory he has lost, the taking place of the accident and that period.
ರಿಪೋರ್ಟ್ ಇದೆ ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು ಅವರು ರೆಡಿ ಮಾಡಿದ ರಿಪೋರ್ಟ್ ನೋಡಿ ಸ್ವಾಮಿ. ಅಂದ್ರೆ
what I am saying is total loss of memory is only in that period. Thereafter, little impaired cognitive function.
Yes.
Not total memory.
Total that impaired cognitive disability directly affected his earning capacity. He can't now because the doctor evidence is very specific.
Now one thing, what has this PW1 stated about his inability to get into matrimonial relationship?
ಅದೇನು ಹೇಳಿಲ್ಲ ಸರ್.
Even the medical experts have not spoken about.
They have also not stated anything.
My lord, it is only a
my elephant is telling.
I am asking him right now. If you interfere, it gets on.
Please,
my lord, because of orthopedic disability accompanied with this severe head injury disability, my lord, my submission is there may be the presumption can be drawn that he lost.
So you are inviting. So this is not a case where his reproductive organ is affected.
Marriage prospects.
It is not a case where because of certain other reasons which was exacerbated by the accident, this claimant says that I can't, I can't discharge marital obligations. It is not such a case. Even he has not set up that case.
Yes, it is only that is.
I just pointed out. Okay.
Yes, correct. Now marriage prospects and marital life marriage prospects is different. Marital life is different.
So there is no special case made out on that ground. A file against a car colluding. Now cross-examination of PW1. Just take me through that. PW1 cross-examination.
Owner of Abhaya Hospital is psychiatrist. Sorry.
Cross-examination of
witness present, petition ಇದರಲ್ಲಿ ಟಾಪ್ ಅಲ್ಲೇ of the court observation ಇದೆ ನೋಡಿ. Petitioner is understanding the question lately and he is not capable of understanding the things.
Let us see now the evidence. Let us see.
Evidence ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಕೋರ್ಟ್ ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ. Court
observation and another were there. You see, what I am little bit finding it difficult is, look at this whole previous transaction. So far as the witness is concerned before the court is the affidavit evidence.
Absolutely.
And documents only lawyers can say. And before that, how can the judge say he understands the questions after taking lot of time? Now we have to assess his Shastri. Unless you listen to this, we have to assess whether his understanding is totally impaired by going through the cross-examination. So now, you see, I do not remember who were.
May I make one submission?
You please take me through the cross.
Sorry.
Then I will hear your submission.
Petitioner is understanding the question lately and he is not.
You have read it. Go on. Next.
Next. I do not remember who were crossing the road on the said date and time. One Varadaraju and another were there at the time of accident. At that time, I was going to attend coolie work. I do not remember.
He remembers that. I do not remember where I was going. This accident occurred 8 a.m. at Marathalli.
It always busy road. I do not remember.
Correct,
the
car
car
number.
number. Huh. It is false to suggest that the said car has not caused this accident and some other vehicle is caused this accident, and false complaint is filed against the said car, colluding with the owners of the police. There was no zebra cross where the road was. It is false to suggest that the accident occurred due to my negligence as I was crossing where there was no space to cross and there were barricades. It is false to suggest that this accident occurred in the middle of the road as per a sketch. I do not remember to which hospital I was admitted immediately after the accident. One Varadaraju who was working with Varadaraju is eyewitness and he filed he is accompanied with him at the time of accident.
That he remembers.
Yes,
That
yes, that he remember. One Varadaraju who was working with has taken me to the hospital. I do not know whether the accident date was given in the hospital or not. Said Varadaraju has given car details and accident in the hospital. Immediately after the accident, Vim's specialty hospital, and I was admitted there for about 1 month. I do not remember the name of the doctor who treated me. I sustained injuries on head, leg, and hand. Surgery was done. It is false to suggest that I sustained only simple injuries. Sorry. Surgery was done. It is false to suggest that I sustained only simple injuries and not admitted as an inpatient and not attended follow-up treatment. And all the medical records are created once. Once I have also taken treatment at Kuppam Medical Hospital. I was not admitted there. I have not produced any other records of Kuppam Hospital except medical bills. Once Dr. Sharan Srinivasan has treated me at Abhaya Hospital. I was admitted for 20 days at Abhaya Hospital. It is false to suggest that I was not treated at Abhaya Hospital as an inpatient. It is false to suggest that medical bills of Abhaya Hospital are created one. It is false to suggest that.
Yes, sir.
Now also I am taking treatment at Abhaya Hospital. It is false to that I have not taken follow-up treatment. It is false to suggest that I have not spent any amount towards treatment, conveyance, and other expenses, as stated by me in the affidavit. It is false to suggest that I am quite normal and I am not suffering any disability, as stated by me in my affidavit. Now, falsely by producing all false documents. It is true to suggest that I got discount of 34,000 and all. It is false to suggest that I do not require 1,50,000 for future medical expenses. I have not produced any records to future treatment. It is false to suggest that 6,000 per month. It is false to say that I have not lost memory and that I am not suffering from headache and giddiness. It is false to suggest that this accident has not affected my marriage prospects and I am capable of doing all the work. Said Varadaraju has filed the complaint. It is false to suggest that as per affidavit, one lorry is also involved in the accident. Witness volunteered that by mistake it is shown as lorry instead of car. I have not shown the spot of the to the police. Said Varadaraju has shown the spot to the police.
Yes, the orthopedic surgeon.
PW4. Dr. G. Gopal Krishna, second para. I am deposing on the basis of wound certificate, discharge summary, and recent clinical and radiological examination done on 14/4/2010. One Jairam, is 21 years. His brief clinical history reveals that he was sustained following injuries due to RTA on 19/5/2000 and treated as inpatient at Vim's Hospital, Bangalore, and so date, and from so and so date at Abhaya Hospital, Bangalore, for head injury, and took up a follow-up treatment at Vim's Hospital for further 6 months on OPD basis as per clinical history. Injuries sustained are as follows: comminuted fracture of right tibia and fibula, head injury. Treatment: fracture tibia was treated surgically by interlocking nailing. Present chief complaint: pain and swelling on right leg. Clinical of the inability to stand for longer duration and walk for longer distance, inability to do manual work. On recent clinical examination, he limps on right lower limb, wasting of right quadriceps muscles and leg muscles with power of 4/5. Range of movements of right ankle dorsiflexion 15 degree, plantar flexion degree, inversion, eversion 10 degree each. Range of movement of right knee flexion 90 degree, extension 10 degree, shortening of right lower leg by 2 centimeter. ಅದು 34 ಇರಬೇಕಾಗಿತ್ತು 32 ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Recent X-ray of right leg shows presence of implants in the right tibia, fracture right tibia fibula right united in the mal position with exorbitant callus. Considering the above all, he has got 30% disability on right lower limb and 15% on whole body. He needs one more surgery for removal of implant, which costs 15,000 rupees. Assessment of disability has been done according to Alimco and my professional experience. Recent I am producing. It is the examination chief.
Yes, yes.
Cross examination with Bexam.
Not necessary. I have finished that. What is it?
So I am not insisting to consider his functional disability as 100%, even though it is so, because to some extent there may be some doubt about his functional disability. That is why my humble request is, considering his age and severe head injury sustained and his evocation, and the disability assessed by the doctor neurologically 47.68% and orthopedically 15% whole body. The disability considered by the tribunal below to an extent of 30% is too low. It is to be enhanced. It is my first.
Whole body disability taken at 30%, is it?
30%. ಇದು ನ್ಯೂರಾಲಜಿಕಲ್ 47.68 plus 15% whole body. Well, as far as these head injury is concerned and disability is concerned, well, the various parts of the brain are, as I understood, functioning and controlling various activities of the human beings. Merely because a person speaking and responding, that cannot be considered as he is fully okay, or he is not suffering from any disability. Because in the absence of any rebuttal evidence, the respondent may choose to let any rebuttal evidence. That is not done by the respondents. And the doctor's evidence that clearly shows, my lord, he's become abnormal, or he is not normal now. And his evocation capacity, earning capacity is adversely affected under these circumstances. And keeping in mind the year of accident and the age of the
what is the income taken by the
3,500 extent is of the year 2009, my lord.
2009 ಅಲ್ಲಿ ಎಷ್ಟು ಇತ್ತು?
4,500 then 4,500.
5,000.
2008 ke 4,500.
5,000.
5,000.
Now, Mr. Vijay Kumar,
Please, my lord.
PW3 and PW4 evidence we should read together.
Yes,
And wound certificate is there, discharge summary exhibit P7 and P8.
Yes,
From reputed hospital, he was inpatient. Nobody can say that these are created documents.
yes, ma'am.
Okay.
Yes, ma'am.
And then exhibit P13, the case sheet is also there.
Yes,
And
ma'am.
this doctor, neurosurgeon has given
Malad.
evidence also, and he has given his certificate. These all show he has suffered injuries resulting in incapacity, which
May I
will
make
have
submission, ma'am?
its own bearing on his ability to work as a coolie. Now you tell me.
Yes, my lord.
Uh,
My lord, please, my lord. My lord, in fact, my lord, I have personally conducted the matter before the tribunal. I have detailedly cross-examined PW3, Dr. Sharan Srinivasan. I have established that he is incompetent to give evidence. First of all, he is not a competent person to give evidence. And moreover, my lord, his evidence clearly establishes that there is total
he has-
falsehood.
No, he
Total
has,
falsehood. Because he
He
wants to help the petitioner, he has given false evidence by inflating and exaggerating the injury and disability. My lord, in fact, I have suggested him to go through the evidence of PW1 in his cross-examination, how he has given the answer, whether this answer shows that is there any slightest mental disability. Your lordship has read the evidence of PW1, particularly the cross-examination, as you rightly observed that because the examination chief is prepared by the advocate and the cross-examination is spoken by the claimant. But he has each and every word, each and every situation, each and every circumstances he has explained. And he has given the perfect answer. Perfect answer, remembering each and everything. That shows, my lord, it is a false case of a mental disability shown by the doctor. And you will ask me kindly appreciate, as per Exhibit P5, my lord, wound certificate at para 10 of the judgment, my lord, CT brain revealed small bleed. It is only a small bleed in tentoral area, right capsule and right frontal area and outer hemisphere fissure. Well, it is only a small blood clot that has been removed. Well, merely because a small clot is there in the head that has been successfully removed and there is no this thing at all. Well, and moreover, my lord, as your lordship has clearly understood by reading the cross-examination of PWM, how perfectly he has given the evidence. It will not give room in a single person that he is mentally disabled or he has got any mental capacity. Even now, my lord, it can be referred again once again to the medical board.
One thing that needs to be pointed out is the cross-examination is only on the time of the accident and the place where it took place, and the effect of the injury suffered.
My lord, he remembers very well. His mental function is very good.
That is not on which the doctor has assessed. He has assessed.
My lord, with great respect to the doctor, my lord, he has total falsehood. Okay. Because he says he was under coma. He was not at all under coma. He was only unconscious for 2 hours. And he says it is wrong. How can it be, my lord? Even I am referring to, my lord, Exhibit P8, my lord, you will ask me kindly see the discharge summary, my lord. Exhibit P, discharge summary. My lord, he says, no history of seizure, vomiting, fever. And my lord, he was unconscious for only 2 hours, that's all. That's all, except this no other deformity. My lord, this doctor, my lord, because we can't understand and because they are the doctors in their different color words they use. My lord, they cannot mislead the court to come to a wrong conclusion. When evidence of PWM himself is very clear like a mirror. It is showing everything about his mental condition. How can this doctor comes and says that because we don't understand anything, he go on telling so many things? With great respect, my lord, he has given total falsehood. And moreover, he has not treated. And moreover, he is not competent to give evidence. And that is why I have referred rightly. See the evidence of PW1, how he has cross-examined. He refused to give the answer to that. Why he refused to that? He can understand. No, he can make out whether he has given proper evidence or not, whether he is remembering all those things or not, whether his mental function is functioning or not.
Okay.
Therefore, my lord, humble submission to your lordship is the evidence of PW3 Dr. Sharan Srinivasan is totally falsehood. his evidence cannot be believed and relied upon. When taking into consideration the evidence of the PW1, particularly cross-examination. And my lord, evidence of PW3 doctor orthopedic surgeon, my lord, first of all, my lord, he has not treated the claimant.
Yes.
He has assessed only on 14/4/2010 only for assessment of disability.
Yes.
First of all, he is not confident and the fractures are united well. And he says 30% disability to the right lower limb and 15% to the whole body. Your lordship knows very well, my lord, 1/3 to be taken in case, even if there is a 30% disability to the lower limb.
Yes.
Again, it is falsehood. As if we don't know anything, the guidelines and the directions and the courts following the procedure that 1/3 to be taken in case of lower limb, 1/4 in case of upper limb. My lord, merely because, my lord, the doctors comes and gives evidence, my lord. Though it is well established in the cross-examination that this evidence is false, their evidence cannot be believed and relied upon. Therefore, my lord, tribunal has rightly, my lord, has taken the disability of the whole body at 30%. And my lord, of course, my lord, at that period of time, 3,500 income was just unreasonable. Recently, my lord, we have taken into consideration of the present condition of the this thing. We have fixed in the legal service authority that is 5,000 rupees per month.
Yes.
Even that, if the matter was decided somewhere in the year 2010 or 11, well, this compensation is on the.
Now this is settled. We can't go behind that.
Yes, no, that's
These
what
are
I'm
set.
making submission.
Fine.
That's why,
This
my lord,
is-
this matter was settled in the year 2013. He has agreed.
ಆಯ್ತು, ಅದು
even
ಈಗ ನಡೀಲಿಲ್ಲ ಅಲ್ಲ, ಅದನ್ನು ಏನ್ ನಾನು ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಆಯ್ತು.
ಹೇರ್ ಮಾಡಿ ಉಪಯೋಗ.
Yes, yes, my lord.
ಹಾ, ತಗೊಳ್ಳಿ.
Therefore, my lord, compensation, my lord, whatever is awarded, well, here, my lord, in fact, we should have filed the appeal regarding the involvement of the vehicle and also the person was crossing the road where there was no zebra crossing. But we have
Your appeal is
no, it is not there, and we have satisfied the award also. But a reasonable enhancement may be made. In fact, we have also agreed before the Lok Adalat, a reasonable enhancement may be made. That's all. But not as the referent poses that he is totally mentally retarded or totally mentally.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, I understood, Vijay.
Please, my lord.
This
I am
appeal
not
is-
telling that he is entitled for any enhancement. He is entitled for enhancement to some extent. I think my humble submission to your lordship is only the difference of income to be taken and the disability may be taken at 30% only and award the compensation. And the rest of the compensation is just
This appeal is at the instance of the claimant seeking enhancement of the compensation in the awarded in the judgment and award dated so and so by so and so. The claim petition alleges that on 19/5/2009 at about 8:30 AM, when the claimant was crossing Outer Ring Road near Krishna Temple in front of DC Courier, Bangalore, a car bearing registration number K02D7561, with its driver driving it in a rash and negligent manner and high speed, dashed against him, resulting in serious injuries to him. Next paragraph. Before the Illinois tribunal, the insured owner of the car remained ex parte. The insurance company entered appearance and filed its detailed statement of objection, denying the material ever mentioned made in the claim petition. Next paragraph. During the trial, the claimant examined himself as PW1. He examined an eyewitness as PW2 and two experts as PW3 and PW4. Exhibit P12, P19 were marked. Whether on behalf of respondents any witnesses were examined?
My lord, 1 minute.
No, full stop. No witnesses were examined for the respondent, and no
Please.
documents were marked for them. Next one. learned tribunal, after hearing the learned counsel on both sides and perusing the records, allowed the claim petition in part, awarding a compensation of ₹4,99,300 with interest thereon at 6% per annum from the date of the petition till the date of realization. Next part. Learned counsel for the appellant claimant submitted that learned tribunal has considered the income of the claimant at a lower rate, and therefore he has awarded the compensation on the lower side. He also submitted that the tribunal has committed serious error in assessing compensation for the loss of earning capacity of the claimant, loss of amenities, and loss of amenities, full stop. He also submitted that learned tribunal has not considered the aspect of awarding compensation for the loss of marital prospects of the claimant. He also submitted that the compensation awarded under the head of loss of earning during the later period is also on the lower side. He therefore submitted that the appeal is required to be allowed by suitably enhancing the compensation. Next slide. The counsel for the responding insurance company per contract contended that the compensation awarded by the learned tribunal is just and reasonable, and no case is made out for enhancement of the compensation already awarded by any acceptable evidence. He particularly laid stress on the answers given by the claimant PW1 during the cross-examination to emphasize that PW1 did not suffer from any loss of cognitive functions, and he was intelligent enough to answer the questions put to him during cross-examination in an intelligent manner. He submitted that PW3 has given false evidence in order to help the claimant, and he was not even competent to give evidence, full stop. Insofar as PW4 is concerned, he submitted that even though he is an orthopedic surgeon, he had not treated the claimant, and therefore his evidence is also not entitled to be looked into. He submitted that the whole body disability assessed by the learned tribunal at 30% is right and proper, and no case is made out to take the whole body disability and the claimant at a higher percentage. In that view of the matter, he submitted that there is no merit in the appeal and it is liable to be dismissed. Next one. I have given my anxious consideration to the submissions made on both sides, and I have carefully perused the thoughts. Certain basic facts are not in dispute. The age of the claimant at the time of the accident was, yes, full stop. his income has not been established by leading any acceptable evidence. The notional income for the year 2009 fixed by the Karnataka Legal Services Authority is rupees
5,000.
5,000 per month. A full stop. The appropriate multiplier applicable to the age of the claimant is 18. Next paragraph. Exhibit 5 is the wound certificate produced, and Exhibit P7 and P8 are the discharge summaries issued by the hospitals where claimant was inpatient. Full stop. Exhibit P13 is the case sheet. Exhibit P17 is the document issued by PW3 after examining the claimant for the purpose of assessing his neuropsychological profile. Not issued. P17 is not issued by PW3. She has not been examined. Exhibit P17. Exhibit P18. That PW4 is Dr. Gopalakrishna, is it?
Yes,
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 sir.
orthopedic.
PW4 has issued Exhibit P18 regarding the physical examination done by him. Next slide. The cross-examination of PW1 shows that claimant was able to answer certain questions in a satisfactory manner. He has stated about the fracture suffered by him, and also the problems caused to him on account of the injuries suffered on his usual functional capacity. Three. Did not treat the claimant during the initial part of his treatment, but subsequently he had treated him in Abhaya Hospital, where also claimant was admitted. Insofar as the impairment suffered by the claimant after she was fully treated is concerned, PW3 has stated as follows. So para 2 para 2 up to whole body disability ಅಂತ ಅಲ್ಲಿ ಇದು ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ 2 ಪೇಜ್ನಲ್ಲಿ ಇದೆ. What is 47? Thus, he has come to the conclusion that the whole body disability is suffered by the claimant is 47.68. Full stop. He was subjected to extensive, elaborate cross-examination on behalf of the insurance company. Even during the cross-examination, she has stated that during the cross-examination, he has stated that he had not produced the questions and answers to the claimant. He has denied the suggestion that he had made false observations in the records. He has denied the suggestion that he was not a competent witness to speak about the cognitive disability suffered by the claimant, and he insisted that behavioral disability can be assessed by psychiatrists or neurosurgeons. The evidence of PW3, it cannot be said that the whole evidence of PW3 is false, but there would be there is some exaggeration, and as evident from the answers given by PW1 during the cross-examination. Accordingly, the whole body disability as assessed at 47.68% by the by PW3 for neuropsychological purposes is required to be scaled down to 25%. Insofar as the evidence of PW4 is concerned, the only criticism leveled against his competence to speak about the disability suffered by PW1 is concerned is that he did not treat the patient. However, PW4, who is a very experienced orthopedic surgeon, has given detailed reasons which are the basis for arriving at the conclusion that the claimant had suffered 15% whole body disability. His clinical examination findings are as follows. So para 5 PW3 affidavit evidence and para 5 para 6 affidavit evidence. The important points to be noted from the same is he had observed shortening of the right leg by 2 centimeters. and he has given the length of right lower limb at 32 centimeters and the normal left lower limb at 34 centimeters. He has also given the range of a restriction in the movement of the right leg. It has to be borne in mind that claimant is a young man, aged 20 years at the time of the accident. In that view of the matter, it is extremely difficult for the claimant to work as a coolie on account of in that view of the matter, the functional disability has to be taken at 40% of the whole body. Stop. Accordingly, the functional disability insofar as due to neuropsychological reasons and orthopedic reasons taken at 65%. Full stop. Next paragraph. In view of the decisions of the Honorable Supreme Court in Irudaya Priya, Amele Sandeep Anuja, and Jagdish versus Mohan, adella citation. Come on. Loss of future prospects will also have to be added to the loss of earning capacity, even in cases of permanent disability suffered due to injuries in the accident. Since the claimant is was aged 20 years at the time of the accident, as per the Constitution bench decision of the Honorable Supreme Court in Pranay Sethi, on a loss of future prospect is 40% of the established income of the claimant. Accordingly, the loss of earning capacity has to be recomputed as follows. 5,000. 5,000 plus 40% into 12 into 18 to 65%. Just bರ್ತದೆ ನೋಡಿ. Next paragraph. Next paragraph. Since the loss of earning capacity is computed by adopting a multiplier method and also by adding loss of future prospect, comma, for loss of amenities, only a token compensation is required to be awarded within bracket Rajkumar versus 2011. Actually, citation. Accordingly, just tribunal loss of amenities.
25,000 for amenities.
Accordingly, there is no need to enhance the compensation awarded under the said head by the tribunal, and the same is maintained. I do not find any supporting material to show that claimant had suffered any loss in his marital prospects. And therefore, I do not find any good grounds to award any compensation under the said head. Insofar as loss of earning during later period is concerned, on account of the injuries suffered and prolonged hospitalization and treatment, claimant would not have been in a position to engage in any gainful employment for at least for a period of 6 months. Therefore, rupees 30,000 is awarded under the head of loss of earning during laid up period, and 6 into 5,000 into 6. In all, ಈಗ rework ಮಾಡಬೇಕು. Loss of earning capacity ಎಷ್ಟೀಗ ಅದು ಬಂತಲ್ಲ. ಆಮೇಲೆ loss of amenities as awarded by the tribunal ಎಷ್ಟು 25,000. ಆಮೇಲೆ loss of earning ಇದು laid up period 30,000. ಆಮೇಲೆ enhanced compensation ನೀವು ಡಿಫರೆನ್ಸ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಬೇಕಂತ ಮೇಂಟೈನ್ ಮಾಡಿದ್ದು ಹಾಗೇನೆ. ಡಿಫರೆನ್ಸ್ ಯಾವ್ದಲ್ಲಿ ಬಂದಿದೆ ಅದು ಎನ್ಹಾನ್ಸ್ಡ್ ಕಾಂಪನ್ಸೇಷನ್ ಅಂದ್ರೆ ಎರಡೇ ಹೆಡ್ನಲ್ಲಿ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ ಮತ್ತೆ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಲೆಕ್ಕ ಹಾಕಿ. ದಿ ಎನ್ಹಾನ್ಸ್ಡ್ ಕಾಂಪನ್ಸೇಷನ್ shall earn interest at the rate of 6% per annum from the date of the accident till the date of deposit. Allowed in part, enhanced by 8 weeks, huh?
Please.
8 weeks.
ಲೈವ್ ಟೆಲಿಕಾಸ್ಟ್ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ಸುಮಾರು ಜನ ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ ಲೈವ್ ಟೆಲಿಕಾಸ್ಟ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ನೌ ಟೆಲಿಕಾಸ್ಟಿಂಗ್ ಇನ್ ಯೂಟ್ಯೂಬ್. ಐ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ಸೆವೆರಲ್ ಮೆಸೇಜಸ್. ಇಡೀ ಜಗತ್ ನೋಡ್ತಾ ಇದೆ ನಾವು ಮಾಡೋ ತಪ್ಪುಗಳನ್ನು.
ನೀವು ಅಂತ ಹೇಳಬೇಕು.
ನಾವು ಅಂತ ಹೇಳಿದ್ವಿ.
I have decided by applying the well-settled principles of law.
83 Kamala DK.
I am appearing for the appellant in this case, my lord.
Yes,
It is argued already, my lord, that learned senior counsel Mahesh has to be argued on the liability ground, my lord.
He promised to give decisions and the rules.
Yes, my lord.
You will do one thing. Learned counsel on both sides to submit brief notes of arguments, list of authorities, and any legal provisions relied upon by them in support of their case on or before next Wednesday, on or before. List on Thursday. Okay, you submit your brief notes of arguments, both with your list of authorities, rules or sections relied upon by you, and then I will hear. It should be before me, so that otherwise hours and hours of hearing,
Please, my lord. I will, my lord. I will.
Briefly confined to the points noted in the argument.
Much of it.
See it in the website. My order. Follow
Much
that.
of it.
84 urgent.
You should comply by Wednesday. Thereupon, I will take it up for hearing on Thursday. Next.
Much of it.
84 urgent. 85 MR Kumar Swamy.
I am appearing for the respondent, my lord, R2 representing. Case of injury, my lord. Our climate enhancement ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ, ಇದು cross objection is not in respect of the MFA 4301, my lord. I appear for second respondent in the cross objection, my lord. The cross objection is in respect of MFA 4828 of 2010, which was disposed of on 25/11/2020.
ಇದು ಖಂಡಿತವಾಗಿ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ತಾನೆ.
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದು ಕನೆಕ್ಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಮೈನ್ ಅಪೀಲ್ ಇವಾಗ ಲಿಸ್ಟ್ ಆಗಿರೋದ್ರಲ್ಲಿ.
ನಾವು ಡೀಲಿಂಗ್ ಮಾಡೋಣ.
MFA 4828.
Okay, different.
Cross subjection is in respect of MFA 4828 of 2010, which is the school of
MFA Rob 72 of 2011 is required to be delinked from MFA 4301 per 2011 as it arises from a different judgment and award.
that
Accordingly.
is disposed of, my lord.
Accordingly, it is delinked. Now, enhancement is sought on what ground? This is an injury case. On what ground? What are the injuries, Mr. Lakshmi Narasimhaya?
My lord, contusion left leg, upper 1/3, fracture of right hip. There is no such document produced by the claimants, my lord. IP 4 days.
One nimsha, wound certificate they have produced or not produced? Exhibit P7 and P8. P7 and P8, wound certificate and discharge.
My lord, that has been noted by the learned judge at the court below. My lords could come to.
1 minute, I will look into the document.
Please, my lord.
Record. Exhibit P7 and P8. Claimant was a government employee.
ಇಲ್ಲ ಸ್ವಾಮಿ ವೆಲ್ಡರ್ ಪ್ರೈವೇಟ್ ಅಲ್ಲಿ ವೆಲ್ಡಿಂಗ್ ಕೆಲಸ ಮಾಡ್ತಾನೆ 6,000 ರೂಪಾಯಿ ಸಂಪಾದಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಬ್ರದರ್ ಇನ್ ಲಾ ವಾಸ್ ದಿ ಪಿಲಿಯನ್ ರೈಡರ್ ಆನ್ ದಟ್ ಡೇ ಆಫ್ ದಿ ಆಕ್ಸಿಡೆಂಟ್.
The learned tribunal has disbelieved P7 and P8.
Exactly, my lord. Page number 12, page number 14, para number 12 may kindly be looked into of the learned judge.
Para number 12.
Last.
As per the evidence of.
Shall I read, my lord? As per the evidence of PW1, the driver of the car is dashed against his motorcycle on the hind portion. But as per the copy of the motor vehicle accident reported marked exhibit P6, front headlight lamp cover damaged, fuel tank right side was dented to inwards. So it is difficult to believe that the driver of Kalis had dashed his motorcycle on the hind portion of the motorcycle. PW1 has not produced the motorcycle MV report of the offending Kalis. Motorcycle of the petition was examined on 19/9/08, 3 days after the accident. PW in his cross-examination has stated that he took his vehicle towards right side to take turn and right side of the Kalis dashed against the right side of his motorcycle. The evidence of PW1 is contrary to the petition arguments regarding the manner in which the accident occurred. The very damages caused the motorcycle disclosed the driver of the Kalis has not.
Ultimately, who is held as negligent?
My lord, come to.
So only quantum is in question.
So
why are you going into that? Now, P7 and P8. P7 and
page number 20, para 17, my lord.
Para 17. Yes.
As per the evidence of, shall I read, my lord?
You have exhibit P7. We will go to that later. Exhibit P7 is wound certificate.
Awesome.
On the left region, left leg upper third. Usual. When was the accident?
Accident is on 6908, my lord.
Pardon me, my lordship. I am for the appellant in this case, my lordship. Serial number 8.
Only quantum is in question, therefore.
No, so my liability.
Just see, liability is based on whom?
Is the respondent number 2, my lordship.
Who is respondent number 2?
Insurance company, my lordship.
Then there is no problem. Only quantum is.
Yes,
Have you
my
gone
lordship.
through, have you gone through your papers?
Yeah, my lordship.
Liability and theory. Look at exhibit P8, discharge summary card, which says non-grievous injury. Discharge card produced by you.
My lordship.
Non-grievous injury. Tribunal has awarded how much?
Total 6,200. Page number 21, my lord.
Absolutely no ground for interfering with that.
Please, my lord.
My lordship, fourth, the 20% contributor negligence has been deducted, my lordship, in this case. 6,200 has been awarded and deducted 20% contributor negligence and awarded 4,960 rupees, my lordship.
Now, on what ground do you want me to interfere with that?
So, 20% contributor negligence illa anta nan ground, Swami.
Under new ಹೇಳ್ತೀರಿ evidence ಏನಿದೆ ಅದಕ್ಕೆ relevant evidence. Where is the discussion, madam?
My lord, page number 20, para number 17, my lord. Typed page 20, para number 17, my lord.
Since there is a negligence on the part of the petitioner in riding his motorcycle, his contribution.
Madam, please, where are you reading?
Impugned order, page number 17, my lord.
That is para 18, para 18. Which paragraph, madam?
In paragraph 17, my lordship,
yes,
page number 17.
As per the evidence. Very, please.
Since there is negligence on the part of petitioner in riding his motorcycle, his contribution is fixed. %, and the liability on the first respondent is fixed at 80%, my lordship.
17 starts with, as per the evidence of PW1, he was aged about, same paragraph you are reading?
My lordship. ಹೌದು ಸ್ವಾಮಿ, ಅದೇ ಪ್ಯಾರಾದಲ್ಲಿ.
ಅದು ಎಲ್ಲಿದೆ? ತಾವು ಓದ್ತಾ ಇರುವಂತದ್ದು ಎಲ್ಲಿದೆ?
After pain and suffering, 3,000 is awarded, my lordship. 1, 2, 3.
Page 21, Swami.
Since there is negligence on the part of the petitioner in riding his motorcycle, so this must have been discussed somewhere else previously. previously ಎಲ್ಲಿ ಅಂತ ತಾವು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
So in the order portion also, the petition is allowed in part allowing compensation of rupees 4,960 in brackets 80% of 6,200 to the petitioner.
Actually, I issue na learned judge discuss ಮಾಡಿಲ್ಲ true my lord. 80-20 ಅನ್ನೋದು ನೀಲ್ ಬೇರೆ ಕಡೆ ಎಲ್ಲೂನು
ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಅದೊಂದೇ ಪ್ಯಾರಾದಲ್ಲಿರೋದು.
When did you lodge the complaint?
18ನೇ ತಾರೀಕು after 2 days my lord. FIR on 18/9/08. My lords could go to that also. ಇವರ ಇನ್ಶೂರರ್ ಇಂದ 2,000 ರೂಪಾಯಿ ಕೂಡ ತಗೊಂಡಿದ್ದಾರೆ ಡ್ಯಾಮೇಜಸ್ ಗೆ ಅಂತ ಇವರು ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್.
And liability is fixed on first respondent, my lordship. That is the owner, my lordship. In the order portion, the liability is fixed on first respondent.
How that direction is sustainable, Mr. Lakshmi Narasimhaya?
So me?
Direction.
Yes, my lord.
Owner to deposit the compensation amount. Though learned tribunal holds that you are 80% liable.
How so?
And, then how respondent number 1 is alone liable? You should be also held liable for 80%.
In regard to this case, one more case has been filed, my lordship, before the MACT Bangalore, my lordship. In that MFA 8428/2010, it is disposed of by fixing the liability in the part of insurance company, my lordship. That is second respondent.
Where is that? A judgment
That judgment
that is
in
what
MF.
Sridhar was submitting, my lord.
Yes, my lord.
Mr. Sridhar was submitting the connected matter. He was representing.
My appeal was in 48/28/2010, my lord.
Where is that copy? When was the order passed?
That is on 25th November 2020, my lordship.
I am not having that.
My appeal came to be disposed of on 25/11/2020.
Number kodi madam, ad yadu?
MFA 48/28/2010, madam.
48/28
48/28/2010.
ಅದು ಇಲ್ಲ ಅನ್ಬಿಟ್ಟು ಡೀಲಿಂಕ್ ಮಾಡಿಸಿದೀರಾ, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು
ಅಲ್ಲ, ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಮೇಡಮ್ 25/11/2020.
ನೋಡ್ತೇನೆ.
ಅದು ಕಂಪನಿ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಕೋರ್ಟ್.
ಹೌದು, ಅದು ಓನ್ಲಿ ರಿಗಾರ್ಡಿಂಗ್ ಲಯಬಿಲಿಟಿ ಇಟ್ ವಾಸ್ ಚಾಲೆಂಜ್ಡ್. ಹ್ಯಾವಿಂಗ್ ರಿಗಾರ್ಡ್ ಟು one case, my appeal came to be dismissed.
Then Lakshmi Narasimhaya, you should have been the first person to mention that. Should you not disclose that to me?
ಇಲ್ಲ, actually ಆ records ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಸ್ವಾಮಿ. But I came to know that he was the appellant in that case. That's what I have mentioned before, my lords. That Sridhar was handling the other case, my lord. Not me. House Swami. Not me, my lord.
Okay. Okay. So that has been disallowed already.
Yes, my lord.
Yes, my lordship.
Okay. So enhancement, what kind of enhancement can be given, madam?
Ma'am, in this case, first thing, the question of liability, my lordship, in this.
That's over.
Okay, madam. Okay, my lordship. In 20% of liability is fixed, 20% contributory negligence has been detected, my lordship.
So in this appeal, liability is entirely fastened on you, isn't it?
I am for appellant, my lordship. It is for.
Payments.
Charge sheet is against whom?
Charge sheet against the respondent and driver of the respondent number 1 vehicle, my lordship.
What do you say about that, Maya?
ಶೀಟ್ ಅವ್ರ ಮೇಲೆ ಇರುವುದರಿಂದ ಸೊ ಲೈಬಿಲಿಟಿ ನನ್ನ ಮೇಲೆ ಬರುದಿಲ್ವಲ್ಲ ಮೇಲ, ಯಾಕಂದ್ರೆ ಟೊಯೋಟಾ ಖಾಲಿ ಸೀಸೆ ಮಾಡ್ಲಿಲ್ಲ ವೆಹಿಕಲ್. IMV subject to not subjected to IMV also.
Same this thing, you lost the appeal in the other case. This same accident, you have lost the appeal in the. Now does it lie in your mouth, Mr.
ಹಂಗಾದ್ರೆ ಇವು ನನ್ನ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಕ್ವೆಶ್ಚನ್ ಮೀನ್ಸ್ ಐ ಹ್ಯಾವ್ ಟು ಫೇಸ್ ಲೈಬಿಲಿಟಿ ಮೈ ಲಾರ್ಡ್.
Okay. This appeal is an instance of the claimant calling in question the correctness of the judgment and award dated 18/5/2010 in so and so by so and so. The claimant has asserted in the claim petition that on 16/9/2008 at about 8 p.m. when he was riding motorcycle carrying registration number K02EF347 on Ring Road, and at that time near Muneshwar Nagar U-turn, the police vehicle bearing registration number KA13A5858 being driven by its driver in a rash and negligent manner and high speed came and dashed to the motorcycle of the claimant from the backside, and on account of the same he fell down and suffered injuries. Next para. In the proceeding before the learned claims tribunal, the owner of the Qualis vehicle, respondent number 1, remained ex parte. Respondent number 2, insurance company, contested the proceedings by filing detailed statements of objection. Next para. During the trial, claimant has examined himself as PW1 and exhibit P1 to P14 are marked. Insurance company examined one of its officials as RW1 and exhibit R1 to R4 were marked. After hearing the learned counsel on both sides and perusing the records, learned tribunal allowed the claim petition in part, awarding a compensation of 6,000 with the interest thereon at 6% per annum from the date of the petition till the date of its deposit. The learned tribunal also held that there was contributory negligence on the part of the claimant appellant to the extent of 20%. Full stop. Further, it held that the driver of the Qualis vehicle not being in possession of valid and effective driving license, owner respondent number 1 was liable to pay the compensation to the extent of 80%, namely rupees 4,960 with interest as ordered. Full stop. Next para. Learned counsel for the appellant submitted that the pillion rider had also filed a claim petition in MEC number 8277/2008, which came to be allowed on 9/10/2009, and the judgment and award came to be challenged by the insurance company. MFA 4828/2010, and the same came to be allowed by this court by judgment dated 25/11/2020. She submitted that on account of entire liability was faced on the insurance company, and liability on the insurance company to pay the compensation amount. She therefore submitted that in this case also, the insurance company should be held liable to pay the entire compensation. She also submitted that the compensation awarded is on the lower side and it is required to be enhanced by this court. Next part. Learned counsel for the respondent insurance company, per contra, submitted that the judgment and award passed by the learned tribunal is just and proper, just and reasonable, and therefore it should not be interfered with, and appeal should be dismissed. Next. As rightly submitted by the learned counsel for the appellant, the pillion rider of the motorcycle driven by the current appellant had filed a separate claim petition in MEC number 8277/2008, which was allowed in part by the learned tribunal on 9/10/2009, and the appeal filed against the same in MFA number 4828 of 2010 was dismissed by judgment dated 25/11/2020. The effect of the said judgment arising from the same accident is to face on the entire liability to pay the compensation is on the insurance company. Under such circumstances, the finding of the learned tribunal, the fact that there was contributory negligence, cannot be sustained, as it would lead to conflicting findings on the same facts in two different claim petitions arising from the same accident. Accordingly, the said finding of contributory negligence recorded by the tribunal is set aside. Next para. In regard to the claim for enhancement of the compensation made, Exhibit P8 is the discharge card, which shows that
In submission, my lord.
a claimant had suffered only.
In submission, my lord. Cross subjection is not in respect of the present appeal, which my lord is disposing of. It is in respect of MFA 4828.
4828 is arising from the same accident.
Same accident, yes, my lord. But cross objection is in respect of MFA 48.
No, I am not. I have delinked it.
Much.
Already delinking order is there. The exhibit P8 discharge card shows that claimant had suffered a simple injuries. Within bracket, non-grievous injuries. Bracket close. The learned tribunal having already awarded rupees 6,200. Yes, 6,200. In this case, no enhancement on the same is required to be made in the facts and circumstances of this case. Accordingly, the claim for enhancement of the compensation is rejected. Let's see following. The appeal is allowed in part. The finding of the tribunal that there was contributory negligence on the part of the appellant to the extent of consent is concerned, it is set aside. The consequently, the insurance company, the respondent to in this appeal is held liable to pay the entire compensation with the interest thereon at 6% per annum from the date of the petition till the date of payment. Trying to deposit 8 fees.
My lord, one submission, my lord. Serial number 83, instead of Thursday, it may be taken on Friday, my lord.
Not Friday. Friday. Sitting.
Or Monday, my lord. Thursday, Friday or Monday, my lord. Or
Code officer, madam. Code officer, madam.
Benny,
Code officer, madam. List number 2 ಏನಾಯ್ತು? Code officer, madam.
Benny.
List number 2 ಏನಾಯ್ತು? List number 2.
ಅದೆಲ್ಲ ಅರ್ಜನ್ ಆಯ್ತು ಅನ್ಸುತ್ತೆ.
ಅಲ್ಲ 87 ರೆಡಿ ಅಂದೆ.
List number 2 ಏನಾಯ್ತು?
ಓಕೆ.
ನೀವು ನೋಟಿಸ್
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಏನಾಯ್ತು?
ತಗೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡಿ. ತಗೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡು.
ಅಲ್ಲಲ್ಲ ಸಾಹೇಬ್ರ ಎದ್ದೋದ್ರ?
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 18.
230 ಬರ್ರಿ.
Madam, list number 2 full ಏನಾಯ್ತು? ಅಜ್ಜನ್ ಆಗಿದೆಯಾ ಇದೆಯಾ?
ವಿಜಯಕುಮಾರ್ ಸರ್.
ಹೇಳಿ ಹೇಳಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಪೇನ್ ರಿಕವರಿ ಆಗ್ಬೇಕು ಅಷ್ಟೇ, ಮತ್ತೇನಿಲ್ಲ.
ಅಷ್ಟೇ ಮಾಡಿಸ್ಬಿಡಿ ಅಷ್ಟೇ.
ಸರಿ ಸರಿ ಸರಿ.
ಈಗ ಪೇನ್ ರಿಕವರಿ ಅಂದ್ರೆ
ಸರ್
BM
ಲಿಸ್ಟ್
ಫಿಕ್ಸ್
ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 19.
ಪೇನ್ ರಿಕವರಿ ಹೆಂಗ್ ಬರುತ್ತೆ?
DL ಇಲ್ಲ ಅವರಿಗೆ, ಯಾರಿಗೆ? ನಿಮ್ ಡ್ರೈವರಿಗೆ.
Code officer, madam.
ಸೆಕ್ಷನ್ 3 ಕ್ಲಾಸ್ 1 ಆಫ್ MA.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದಾಗಿದ್ಯಾ? ಫೈಂಡಿಂಗ್ ಇದೆಯಾ?
Code officer ಅವರೇ.
ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ಯಾರಾ 3 ದಲ್ಲಿ ಇದೆ ನೋಡಿ.
ಹಲೋ.
ಪ್ಯಾರಾ 7 ಅಲ್ಲಿ ಇದೆ ಸರ್.
Code officer ಅವರೇ.
ವಿಜಯಕುಮಾರ್.
ಹೇಳಿ ಹೇಳಿ.
ಜಡ್ಜ್ಮೆಂಟ್ 7 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
ಹೌದಾ?
ಪಿ ಫೈಲು ಅದು
Code officer ಅವರು ಇದ್ದಾರಾ?
ಬೇರೆಯವರು ಯಾಕೆ ಮಾತಾಡ್ತಾರೆ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ,
ಬೇರೆಯವರು ಅಲ್ಲಿ ಲೆಫ್ಟ್ ಆಗ್ಬೇಕು, ಅಲ್ಲಿ ಸುಮ್ನೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 25. ಸೀರಿಯಲ್ ನಂಬರ್ 25.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಫುಲ್ ಏನಾಯ್ತು ಅಂತ ಯಾವಾಗ ತಗೊಂತಾರೆ? ಲಿಸ್ಟ್ ನಂಬರ್ 2
ಆಗೋಗಿದೆ, ಕರೆದಿದ್ದಾರೆ. ಕರೆದ್ಬಿಟ್ಟು ಎಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಅಷ್ಟೇ.
ಅರ್ಜನ್ ಆಯ್ತು ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಸರ್.
2 ವೀಕ್ಸ್ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 19.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಫುಲ್ ಹಾಕಿದ್ರೆ ಸರ್.
ನಮ್ದೊಂದಿತ್ತು, ಅದನ್ನ ಇದ್ ಮಾಡಿದ್ರು. 2 ವೀಕ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲದು ಫುಲ್
ಹಂಗೆ ಮಾಡಿದ್ದಾರೆ. ಅದೇನ್ ತಗೊಳಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ.
ಹೌದಾ?
ಅದು ಬೇರೆ ಕೋರ್ಟಿಂದಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಈ ಕೋರ್ಟ್.
ಅದೇ ಬೇರೆ ಈ ಕೋರ್ಟಿಂದ ಅಲ್ಲ, ಅದು ಬೇರೆ ಕೋರ್ಟಿಂದ. ಅದು ಪ್ರದೀಪ್ ಸಿಂಗ್ ಯರೂರು ಅವ್ರು.
ಅಲ್ಲ ನಮ್ದು ಈ ಕೋರ್ಟ್ ಇಂದ ಇದೆ ಸರ್.
ಶಿವಕುಮಾರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಏನಾಯ್ತು?
ಇದು ಬ್ಯಾಕ್ ಬರೋದಾಗೆ
ಶಿವಕುಮಾರ್. ಶಿವಕುಮಾರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಲಿಸ್ಟ್ ನಂಬರ್ 2 19 ಮ್ಯಾಟರ್. ಎನಿ ಐಡಿಯಾ?
ಕೋಡ್ ಆಫೀಸರ್.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ 25 ಏನಾಯ್ತು ಸರ್?
ಕೋಡ್ ಆಫೀಸರ್.
ಇಲ್ಲ, ಊಟಕ್ಕೆ ಹೋಗಿದಾರೆ ಬಿಡಿ ಅವರು.
ಹೌದಾ?
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 97 ಏನಾರ ಐಡಿಯಾ ಇದೆಯಾ ಸರ್?
What answer? What up, sir?
Court officer, sir. Court officer, sir. Court officer, sir. Code officer, sir. Code officer, sir. Code officer ಅವರೇ. ಹಲೋ ಹಲೋ
ಹೇಳಿ ಸರ್.
ಲಿಸ್ಟ್ 2 ಏನಾಯ್ತು ಸರ್? ಲಿಸ್ಟ್ 2
2 weeks ಅಜ್ಜನ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ತಮ್ಮದು?
ನನ್ನ ಸೀರಿಯಲ್ ನಂಬರ್ 12.
2 weeks.
ಸೀರಿಯಲ್ ನಂಬರ್ 16, ಸಾರಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 16 16.
ಸರ್ ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಕರಿತೀರಾ? ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಕರಿತೀರಾ? ಹಲೋ
ಸರ್, ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್
ಕರಿತೀರಾ?
ಕರಿತೀವಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು
115 116.
ಸರ್, ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 90 ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಾ ಸರ್? 90 ತಗೊಂಡಿಲ್ಲ. ಓಕೆ, ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ಲಿಸ್ಟ್ 2 1 2 3 ಕೆಪ್ ಬೈ ಅಂತ ಹೇಳಿದ್ರು, ಯಾವಾಗ ತಗೋತಾರೆ
ಮೇಡಮ್? ಲಿಸ್ಟ್ 2 1 2 3 ಗೆ ಕೆಪ್ ಬೈ ಅಲ್ವಾ?
ಯಾವಾಗ ತಗೋಬಹುದು ಸರ್?
ಹೌದು ಸರ್, ಕೆಪ್ ಬೈ ಏನೇ ಅದು.
ಅದೇ ಯಾವಾಗ ತಗೋಬಹುದು? ಆಫ್ಟರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಥವಾ 230 ಅಂತ ಅಷ್ಟೇ
ಸರ್? ಅದು ಗೊತ್ತಿಲ್ಲ, ನೋಡ್ಬೇಕು ಸರ್ ಬಂದ್ಮೇಲೆ, ಸಾಹೇಬ್ರ ಬಂದ್ಮೇಲೆ.
ಆಯ್ತು, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
100 ಮತ್ತೆ 105 ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ ಸರ್.
ಸರ್, ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಅದು 2 weeks ಏನಾ?
ಮೇಡಮ್ 100 105 ಎರಡನ್ನೂ ತಗೊಂಡಿಲ್ಲ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್, ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಅದು ಅಜ್ಜನ 2 weeks.
ಹೌದು,
16. ಓಕೆ. ನಾಳೆನು ಸಾಹೇಬ್ರ ಇನ್ಚಾರ್ಜ್ ಅಥವಾ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ತದ ಸರ್ CRP ಮ್ಯಾಟರ್ಸ್ ನಾಳೆ?
ಅಲ್ಲ, ನೋಟಿಫಿಕೇಶನ್ ಏನಾದ್ರು ಬಂದಿದ್ಯಾ ಸರ್? ಯೂಶುವಲ್ ಸಂಜೆ ಗೊತ್ತಾಗ್ತದೆ ನಮ್ಗೆ.
ಹೌದಾ? ಯಾವ್ದು ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು.
ಸಂಜೆ ಒಮ್ಮೆ ನೋಟಿಫಿಕೇಶನ್ ನೋಡ್ಬೇಕು ಸರ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್, ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 21 ಏನಾಗಿದೆ ಸರ್?
ಸರ್, ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಇಂದ ಹಿಡಿದು ಕೊನೆ ತನಕ ಎಲ್ಲಾದು ಅಡ್ಜರ್ನೇನೆ 2 weeks.
ಓ ಹೌದಾ? ಇದು ಅರ್ಜೆನ್ಸಿ ಇದೆ, ಸಬ್ಮಿಷನ್ ಮಾಡಬಹುದು.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1 2 3 ಬಿಟ್ಟಿನ ಎಲ್ಲ ಅಡ್ಜರ್ನ್.
ಓಕೆ.
ಸರ್, ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಏನಾಗಿದೆ ಸರ್?
ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1 2 3 ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲ ಅಡ್ಜರ್ನ್.
ಓಕೆ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ
ಮೇಡಮ್.
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು ನಡೀತಾ ಇದೆ ಮೇಡಮ್? ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು ನಡೀತಾ ಇದೆ ಅಂದೆ?
ಸರ್ ಬೆಂಚ್ ಆಫೀಸರ್ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಲಿಸ್ಟ್ 2 ಏನಾಯ್ತು? ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಅರ್ಜೆಂಟ್ ಸರ್. ಓಕೆ
ಕಾಲ್ ಮಾಡಲ್ವಾ?
ಹಲೋ, ನೀವೇ ಹೇಳ್ಬಿಡಿ, ನೀವೇ ಹೇಳ್ಬಿಡ್ರಿ.
ಸರ್ ಲಿಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಮೆನ್ಷನ್ ಮಾಡಬಾರ್ದು ಸರ್?
ಕನ್ವಿನ್ಸ್ ಮಾಡ್ತೀವಿ ಅಂತ
ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೋದು.
ಇಲ್ಲ, ಆಲ್ರೆಡಿ ಅರ್ಜೆಂಟ್ ಆಗಿದ್ರೆ ನಾಳೆ ಮಂಡೇಗೆ ಹೋಗ್ತೀವಿ. ಅಲ್ಲೆಲ್ಲ ಕೂತ್ಕೊಂಡು ಇಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗೋಗಿದೆಯಪ್ಪ ಅಂದ್ರೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ನಾಳೆ ಜಾಸ್ತಿ
ಹೇಳಿ ಮೇಡಮ್.
ತುಂಬಾ ದಿವಸ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 99
99 ಇನ್ನೂ ಕಾಲ್ ಮಾಡಿಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 99 ಏನಾಗಿದೆ ಸರ್? ಕಾಲ್ ಮಾಡಿಲ್ಲ. ಎಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಲ್ಲ ಯಾರು?
39 ನೋಟಿಸ್
99
39 ನೋಟಿಸು.
99
ಅದನ್ನು ಕಾಲ್ ಮಾಡಿಲ್ಲ
ಸರ್. ಫಸ್ಟ್ ಲಿಸ್ಟ್
Okay, fine.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 121 ಇದೆಯಾ, ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ ಸರ್?
ಬೆಳಿಗ್ಗೆ ತಗೊಂಡ್ರ ಸರ್ ನೀವೇನಾದ್ರು?
ನಾನು ಮೂವ್ ಮಾಡಿಲ್ಲ, ಅದರ್ ಸೈಡ್ ಮಾಡಿದಾರ ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಇಲ್ಲ,
ಇದೆಯಾ?
ಇದೆ. ಓಕೆ, ಸಾಹೇಬ್ರು ಬರೋ ತನಕ ಮ್ಯೂಟ್ ಆಗಿರ್ತೇವೆ.
ಮೆಮೋ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಕಾಲ್ ಮಾಡಬೇಕು.
ಹಲೋ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಲಿಸ್ಟು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೋದಾ ಸರ್ ಸಾಹೇಬ್ರಿಗೆ? ತುಂಬಾ ದಿನದಿಂದ ಹೇಗೆ ಹೋಗ್ತಾ ಇದೆ, ಮಂಡೇಗ್ ಬೇಕು. ಹಲೋ
Sir. Court officer, sir. Court officer. Court officer.
ಹೇಳಿ
ಸರ್, ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಅಡ್ಮಿಷನ್ ಲಿಸ್ಟ್ ಇನ್ನೂ ತಗೊಂಡಿಲ್ವಾ ಸರ್?
ಎಲ್ಲ ಅಡ್ಜಾನ್ ಆಯ್ತು ಸರ್, ಲಿಸ್ಟ್ 2 ಪೂರ್ತಿ.
ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 23. ಹಲೋ
ಹೇಳಿ
ಸರ್, ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 23.
ಹೌದು, 17ನೇ ತಾರೀಕು.
ಅಯ್ಯೋ ಸರ್, ಅರ್ಜೆನ್ಸಿ 17 ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 21 ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 21
2 ವೀಕ್ಸ್.
ಓಕೆ.
ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ನಂಬರ್ 21 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ನಂಬರ್ 51 ಏನ ಸರ್?
ಫೈಲ್ಸ್ ಇಲ್ಲ ಸರ್, ಏನ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ? ಫೈಲ್ಸ್ ಎಲ್ಲ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಕಳಿಸಿದ್ದಾಯ್ತು
ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಏನ ಸರ್?
51. ಹಾ, ಟಿಸಿಆರ್ ಕಾಲ್ ಆಗಿದೆ.
ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಏನಾದ್ರು ಆರ್ಡರ್ ಆಗಿದೆಯಾ ಸರ್?
ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ.
25 ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಲಿಸ್ಟ್. ಬಂದರು ಸಾಹೇಬ್ರು.
ಮತ್ತೆ ಅಜ್ಜನಾಗಿದೆ ಅಂತ ಕೇಳಿದ್ರೆ ಇಷ್ಟು ಎಲ್ಲ ಅಜ್ಜನಾಗಿದೆ ಅಂತ ಕೇಳಿದ್ರೆ
ಮೈ ಲಾರ್ಡ್ಸ್ ಕೈಂಡ್ ಪರ್ಮಿಷನ್.
ಅದು ಮಾರ್ನಿಂಗ್ ಕೇಸ್ ಏನಾದ್ರು ಇರ್ಬೋದು. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಏನಾದ್ರು
ಬರ್ತಾರೆ.
My
Serial
lord,
number
kind submission.
86.
My lords,
86.
one submission. My lords, one submission. List number 2, my lord, serial number 21. There was a conditional interim order, my lords, which was passed in this matter. This is my lords, regarding the payment of arrears of maintenance. Partially, my lords, I have complied, and I have filed an application, my lords, for extension of time, my lords. There is some urgency in the matter.
Let's wait. Let the case come up, then we'll see. Because
The matter, I was told, my lords, the matter has been adjourned by 2 weeks, my lords. It could be taken up on Monday, my lords.
then it would have been signed. I can't do anything.
86. List 1.
May I make a
Vishwanath
submission?
Shettar.
May I make a
Vishwanath.
submission?
Yes, 86.
I make a
86.
submission. First respondent.
Vishwanath Shettar.
I appear for first respondent.
Yes.
Matter is being posted several times, but no representation by the appellant.
This is injury case or death case?
Case of an injury, my lord.
He is seeking enhancement.
He is seeking enhancement, but doctor has not given any opinion about the disability, my lord.
Tribunal has taken into consideration disability.
But total, my lord, 1,41,300.
ನನ್ನ ಪ್ರಶ್ನೆ
PW
ಟ್ರಿಬ್ಯುನಲ್ ಏನಾದರೂ ಒಂದು ಡಿಸೆಬಿಲಿಟಿ ಇಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಅಂತ ತಗೊಂಡಿದ್ಯಾ?
ಹೇಳಿಲ್ಲ. PW2, my lord, evidence of the doctor may kindly be looked into.
ಟ್ರಿಬ್ಯುನಲ್ ಏನಾದರೂ ಇಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಡಿಸೆಬಿಲಿಟಿ ಇದೆ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ.
Tribunal says that doctor has not given any opinion.
So how much was given? 1,41,300.
41,312, my lord.
Being medical loss of earnings during later period.
Evidence of PW2 may kindly be looked into, my lord.
Evidence of PW2. What is it?
Type at page 10, para 15 and 16, my lord.
Type at page 10.
And particularly para 17, my lord.
17. Yes.
PWT, the doctor has reported that the petitioner has sustained disability to an extent of 15% of the whole body. And he stated that the range of movement of the left knee and ankle are restricted, and there is a pain. The implants are still in the fractured leg. PW1 has reported that due to this accident, he is unable to do his job. Of course, he has not produced his driving license. PW2, the doctor, has stated that he has not given any opinion regarding the functional and occupational disability of the petitioner. Therefore, the tribunal has taken as 10% and calculated more.
Which is the disability certificate?
10%, my lord. Para 17 at the bottom, my lord.
Is there any disability certificate marked in this?
I take the disability of the petitioner to the whole body at 10%. And I have taken the income at 3,000 per month. And thereby, my lord, the compensation has been.
Is there any disability certificate marked in this case?
No, my lord. No evidence.
No disability certificate marked.
No. Only wound certificate and discharge summary is produced, my lord. No disability certificate. And doctor says that he can't give disability. However, taken 10%, my lord, for the purpose of computing, my lord, the loss of earning capacity.
How much was given towards medical expenses?
Medical expenses for future medical expenses 8,000 granted.
Actual medical expenses.
9,512 my lord.
Award ಮಾಡಿದ್ದು only 9,000.
9,512 and 8,000 future medical expenses.
9,336.
9,512 is the medical expenses and future medical expenses 8,000.
They have actually produced bills of 59,087. Discount, there is discount. 54,337.
May I invite your worship attention to my lord, typed page 10, paragraph 15, my lord.
1 minute.
Okay. 1 minute. Typed page 10. I hold that the petitioner is not entitled for medical expenses under duplicate bills. Further, the bills at exhibit 772, 731 are original bills for which the petitioner is entitled to. That comes to 9,500. Duplicate bills are not considered.
Where is this duplicate bill? Where did he get this? Where is the evidence regarding that duplicate bill? Where is the evidence?
That is the doctor, my lord.
whom these bills were cross-examined.
And his driving license was not produced.
No, I am asking something, you are answering something else. There is no difficulty in hearing, no? Where these medical bills were proved through claimant or some other witness?
But through the claimant only. Therefore,
where is it? You have the deposition?
No, I don't have the deposition.
Okay, then I.
PW, typed page 10, my lord, of the judgment, where the my lord tribunal observes that duplicate bills. Therefore, my lord, only under exhibit P7 to 31, 9,512 has been granted, which covers the said exhibits.
Discharge summary. What is the date of the accident, Mr. Mahesh?
Date of accident, my lord? 5/12/2008, my lord, at 4:30 p.m. Motorcycle and auto, my lord. There was a permit issue also The company had not preferred any appeal, my lord, on the issue of permit.
Okay. Discharge on 12.
Officer of the insurance company was examined as RW1. Policy and permit was produced.
Was he again admitted to the hospital on 23/1/2009?
Yes, my lord. That is, my lord, he had a medical claim, my lord. That's what, my lord, the learned member referred to.
No, was he admitted again?
But in typed page 10, my lord, the member refers to, my lord. Petitioner has not examined any witness on behalf of the Manipal Hospital to prove that he has not claimed the amount under any health insurance policy. If there was any claim under the health insurance policy, the insurance company will directly pay the amount to the concerned hospital. So under these circumstances, I hold that the petitioner is not entitled for the medical expenses under duplicate bills. Bills produced were duplicate. So he refers to, my lord, only for exhibit P7 to 31 and 9,512 has been granted rightly.
Was there any cross-examination of this witness on that? That he had claimed from any insurance company and all that? Was there any cross-examination? Was there any cross-examination? He has not claimed any name.
May kindly be looked into, my lord.
I have looked into that, and thereafter I am asking, and you are again asking me to look into the judgment. What is his evidence?
Yes. Petitioner has produced 31.
In the
cross-examination, he admits that the inpatient bills at exhibit P7 series is a duplicate bill. He said that he has lost originals, but he said that he has not claimed any medical reimbursement under the any health insurance policy. He denies that he has also made claim against so on so on.
He denied that, saying that there is no presumption that anybody claims.
Considered, my lord, he must have given it to, my lord, the insurer of, my lord, a mediclaim and obtained, my lord, the payment will be made to the hospital directly. At the time of admission, my lord, the hospital authority will require whether he is covered under the mediclaim policy. If that is so, my lord, the amount will be paid by the insurance company, my lord, directly to the hospital.
$1,080, 4,500 income. What is his age?
19 years, my lord. And he had not produced the drawing license also.
This is an appeal at the instance of the claimant seeking enhancement of the compensation awarded. The judgment and award dated so and so in MEC so and so by so and so. The claimant has asserted in the claim petition that on 5/12/2008 at about 4:30 p.m. while he was riding a Suzuki Dragon motorcycle bearing registration number K02U8071 near Bhagirathi petrol bunk, an auto rickshaw bearing registration number KA03B5118 proceeding towards Hoskote came in a high speed and in a rash and negligent manner and dashed to the motorcycle, resulting in grievous injuries to him. Before the learned tribunal, the owner of the auto rickshaw, respondent number 2, remained absent and he was placed ex parte. Insurance company contested the proceedings by filing a detailed written statement, wherein it has denied the material averments made in the claim petition. Next, during the trial, the claimant has examined himself as PW1 and he has examined a medical expert as PW2. Exhibit P12, Exhibit P15 were marked. Respondent examined one of its officials as RW1 and Exhibit R1 and R2 were marked. Next, after hearing the learned counsel on both sides and perusing the records, learned tribunal allowed the claim petition in part and awarded a compensation of ₹1,41,312 with the interest thereon at 8% per annum from the date of the petition till the date of deposit. Next part. It is urged on behalf of, it is urged in support of the appeal that compensation awarded is highly inadequate and learned tribunal was completely in error in disbelieving the medical bills produced as per Exhibit P7. Full stop. It is urged that as per the bills produced from Manipal Hospital, as per Exhibit P7, rupees 73,546 was paid, and in spite of the same, learned tribunal has awarded only rupees 9,512. It is also urged that learned tribunal has not assessed the permanent disability suffered by the claimant as per the relevant principles applicable to the same, and has thereby awarded a meager compensation under the head of loss of earning capacity. Stop. It is therefore urged that the award under challenge is required to be modified and compensation is required to be enhanced by allowing the appeal. Next part. Learned Counsel for the insurance company per contract contended that since the duplicate bills were produced, Learned Tribunal has disbelieved the same and it has awarded rupees, how much was awarded? Rupees 9,000.
9,512.
For medical expenses.
Yes. Future medical expenses 8,000.
9,512 towards medical expenses. And therefore, the finding of the Learned Tribunal in this behalf is right and justified. He also submitted that the permanent disability assessed at 10% by the Learned Tribunal cannot be called in question as the tribunal, as the fact-finding authority, has, after discussing the evidence, has come to such a conclusion. He therefore submitted that there is no merit in the appeal and it is liable to be dismissed. Next part. I have given anxious consideration to the rival contentions and I have perused the records. Next part. The insurance company has not filed any appeal. Calling in question the judgment and award rendered by the Learned Tribunal below. Next part. Insofar as the medical expenses is concerned, Learned Tribunal has awarded only rupees 9,512. 9,512. Full stop. The Exhibit P6, Exhibit P6 is the discharge summary issued by Manipal Hospital, Airport Road, Bangalore. It clearly shows that the claimant was inpatient for the period between 5/12/2008 and 12/12/2008. The exhibit, full stop. Exhibit P7 are the medical bills produced, which is for the period in which claimant was inpatient in Manipal Hospital. And the duplicate bill has been countersigned by the accounts department of the Manipal Hospital. Another duplicate bill, which is also duly authenticated by the accounts department of Manipal Hospital, is for the period is for 23/1/2009, when the claimant was again admitted to the said hospital. These totally cover the medical expenses of 75,546. The only ground on which Learned Tribunal has refused to take note of these bills is that it is superscribed as a duplicate bill. Firstly, it has not taken note of the fact that accounts department has duly authenticated the bills. Secondly, the reason given by the Learned Tribunal is that duplicate bills could not be accepted because there is a possibility of the claimant having made a claim before the insurance before any insurance company towards medical expenses, in which event, even as per the learned counsel for the insurance company, direct payment would have been made by the insurance company itself to the hospital. No such mention is found in the duplicate bill issued by the Manipal Hospital, which is on record. Manipal Hospital is undoubtedly a very reputed institution. And the records indisputably showing that claimant was an inpatient for the period between 5/12/2008 and 12/12/2008, and most of the bills covering the same period. Also, learned tribunal should not have lightly disregarded the bills on imaginary grounds. The above view of mine is supported by the fact that even during the cross-examination, the claimant has vehemently denied the suggestion that he had made any claim before the insurance company. There is no presumption that every claimant is covered by medical insurance, and he would have made some claim before such insurance companies. And in cases where duplicate bills are produced, the inevitable conclusion ought to be that such false claims have been made. In the face of his denial during the cross-examination, that he had not made any such claim before any insurance company, and the evidence clearly showing that he was inpatient for the said period in Manipal Hospital, a learned tribunal was unjustified in rejecting the claim for the expenses which are covered by the bills produced. Full stop. Under circumstances, under the head of medical expenses, the claimant is entitled to be awarded a sum of ₹75,546, and accordingly it is allowed. Next paragraph. Learned tribunal has assessed the whole body disability at 10%. I find that the conclusion of the learned tribunal in this behalf is unexceptionable, and therefore it is confirmed. However, even though accident had taken place in the year 2008, the notional income fixed by the learned tribunal at ₹3,000 per month is on the lower side. And since claimant has not conclusively established his monthly income, notional income fixed by the Karnataka Legal Service Authority, which is ₹4,500.
4,000.
4,500. 2080. 4,500 for the year 2008 should be taken as the income of the claimant hearing. Further, as per the decision of the Honorable Supreme Court in Irudaya Priya Amele Jagdish versus Mohan, adella citation ಕೊಡ್ತಾರೆ. And Kanuja. comma, loss of future prospect is required to be added to the established income, even in cases where permanent disability is suffered.
10% disability, future prospect does not come into picture.
Your contention has to be rejected. You must inform yourself of the current position of law. I have mentioned the Supreme Court decision. You must know something, Mr. Mahesh, without reading decisions of the Supreme Court. There are 3 decisions. I have mentioned that in the order. Just now I have dictated. You must listen to what is being
My
said.
submission is that 10% disability.
Rejected. Full stop. Now don't interfere. It has to be added. Full stop. Accordingly, the loss of his earning capacity has to be recomputed as follows: 4,500 plus 40% into 12 into 18 into 10%. Just one ನೋಡಿ. Since the claimant has suffered fracture of the lower limb, under the head of pain and suffering, a sum of rupees 40,000 is awarded. He was an inpatient for 8 days on the first occasion, and on the another occasion he was inpatient for 1 day. Therefore, towards attendance expenses, a sum of rupees 2,000 is awarded. Towards conveyance expenses, another sum of rupees 2,000 is awarded. Towards nourishing food, a sum of rupees 3,000 is awarded. Pain and suffering. Towards loss of amenities, a notional, a token sum of rupees 15,000 is awarded. Within bracket, Rajkumar versus this thing, 2011 an idea. But since he had suffered fracture of the lower limb, he would not have been in a position to engage himself in any gainful activity for a period of 4 months, and therefore a sum of rupees 4,500 into 4 is awarded towards the loss of earning during the laid-up period. The sum of rupees 8,000 awarded by the learned tribunal towards the future medical expenses is maintained. Thus, in all, claimant is entitled to be awarded a compensation of rupees. Adrinda, learned tribunal has already awarded rupees 1,41,312. Hence, enhanced compensation is rupees 1. On the enhanced compensation, claimant is entitled to interest at the rate of 6% per annum from the date of the petition till the date of payment. Hence, the following. The appeal is allowed in part in modification of the compensation awarded, claimant is in addition to the compensation already awarded, the appellant is entitled to enhanced compensation of rupees enhanced with the interest thereon at 6% per annum from the date of the petition till the date of payment. How much time? 4 weeks or 6 or 8?
4 weeks.
The compensation awarded shall be deposited by the insurance company within 4 weeks from the date of receipt of certified copy of this judgment. Transmit the record to the Learned Court below 4 weeks.
M.R. Kumar Swamy.
Appear for appellant, my lordship.
I am for second respondent, please, my lord. My appeal is filed on the liability, please, my lord.
Who appears? Ravish Bindi?
I am for Ravish Bindi.
Then Vijay Kumar appears for whom?
Yes, sir. Vijay Kumar for BMTC, please, my lord.
ಎರಡು ವೆಹಿಕಲ್ ಇನ್ವಾಲ್ವ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ. ಅದು against the same arising the same accident. We have also filed a cross objection on the ground of the liability. The driver of the event has no DL as on the date of the action. Therefore, charge sheet filed under section 3, class 1, read with 181 of MU Act. Now I discussed with the.
1 minute. Your vehicle, BMTC bus is insured with the private insurance.
United India, please.
Fine, I understand. Now the appeal is by the claimant,
for
Yes, my
enhancement.
lordship. For enhancement.
My appeal is on liability, please, my lord. Pay and recovery order to be passed.
And lower court tribunal award has been satisfied by the insurance company, my lordship.
I'm not denying.
On what grounds you are seeking enhancement, madam?
My lordship, in this case,
I will hear you because the appellant's learned counsel is here. I will hear her first. Thereafter, I will hear you. Please.
One submission, please, my lord. In my appeal, kindly direct the M.R. Kumaraswamy for direct to take the R1 and D.J. for R2, please. Next 15 days, he is going to furnish the DL. If the DL is there, we have to pay the compensation. Otherwise, the pay and recovery order to be passed.
Aye.
Kindly granted 2 weeks time, please. He told me he is going to furnish the DL.
Very well, very well.
If
Madam,
they pay the DL, pay and for it. Otherwise, pay and recovery.
My lordship.
Learned counsel Shri Ravish Bindi prays for time. List after 2 weeks. Date. Website nalli date irutte. Neevu nodkolli adana.
Please.
ಕೊಡ್ಬೋದು ಸರ್ M.R. Kumaraswamy R20 R2 connected.
2 ವಾರ ಅದೊಂದು ಡೇಟ್ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ
88 O Mahesh.
ಇದು ನೋಟಿಸ್ ಮಾಡಬೇಕಲ್ಲ.
For respondents, my lord, claimants in this matter, my lord, I pray for 2 weeks time in this matter, my lord. Lord.
88 O Mahesh.
I am for respondents in both the appeals, my lord. I pray for 2 weeks time in this matter, my lord.
ತಮ್ಮ ಹೆಸರು?
I am R. Chandrasekhar for lawyer's side.
R. Chandrasekhar for new claimants ಈಗ?
ಹೌದು ಸ್ವಾಮಿ, claimants.
The claimants respondent prays for ಎಷ್ಟು ಟೈಮ್?
2 weeks ಕೊಡಿ ಸ್ವಾಮಿ.
2 weeks time. ಮಹೇಶ್, ಇದು ಲಯಬಿಲಿಟಿ ಕ್ವಾಂಟಮ್ ಅಂದ್ರೆ 2 ಕ್ವಶನ್.
Liability and maintainability ಎರಡು ಇದೆ ಸ್ವಾಮಿ.
Mr. Mahesh?
Yes, madam.
You are questioning on both grounds or only liability?
Maintainability and also, my lord,
that is liability you are denying on what ground?
My lord, 163A, he himself was charge sheeted. And the income, my lord, has been artificially brought down to make a claim under section 163A.
163 is no fault. So you have some decision on in your favor.
Lord, my respectful submission, my lord, in the absence of Lord evidence, Lokadala chart would be taken into consideration. If the year of accident is taken into consideration, my lord, it will exceed 40,000 per annum.
ಸ್ವಲ್ಪ difficult. If he wants to forego the income, how can I force?
He has to forego all things, not against the insurer. He can't do that. He can't show any condition to the insurance company.
No, this is a very arguable point. ಆದ್ರೆ ಏನಾದರೂ ಡಿಸಿಷನ್ ನಿಮಗೆ ಇಷ್ಟು ವರ್ಷದಲ್ಲಿ ಏನಾದರೂ ಒಂದು ಡಿಸಿಷನ್ ಇದ್ರೆ ನೀವು ಕೊಡಬೇಕು. ಇಲ್ಲ ಅಂದ್ರೆ I will have some difficulty in accepting because we are accepting this kind of, they voluntarily giving up their hiring.
It is only question of fact and appreciation of the fact by the court.
ಸರಿ, ಈಗ ಸಾವಿರಾರು ಡಿಸಿಷನ್ಸ್ ಗಳು ಇಂತವು ಏನು ಕಡಿಮೆ.
I'm only, my lord, logically I am putting forth, my lord, my submissions. In the absence of evidence, my lord, Lokadala chart is taken into consideration considering the year of the accident. If that is so, my lord, there can't be any two distinct, my lord, category.
It is good. Your earnest effort for the insurance company is good, but I am asking you, another by chance, is there any authority in support of your contention?
To my knowledge, my lord, there is no. My only thing, my lord, it's a question of fact. They do it because 163A, my lord, is only specifically mentioned for a group of people whose income does not exceed 40,000 per annum. That's for the schedule.
Very sorry. Okay, 2 weeks ನಿಮಗೆ.
ಹೌದು ಸರ್, 2 weeks.
2 weeks. ಅದೊಂದು ಡೇಟ್ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ you will find the date.
Oblige, madam, oblige. Much oblige.
89 R Pramod.
I'm appearing for
89.
the appellant, my lord.
I am appearing for the appellant in the connected matter, my lord. My lord, ಪ್ರಮೋದ್ ಅವರು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ. ನಾನು ಲೈಬಿಲಿಟಿ ಕ್ವಶನ್ ಮಾಡಿದ್ದೆ. ಆಕ್ಚುಲಿ ಮೈ ಅಪೀಲ್ ವಿಲ್ be dismissed by this court, my lord. On the ground that the issue DL issue ಮೇಲೆ ಹಾಕಿದ್ದೆ, ಅದು ಆಕ್ಚುಲ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. ಲೇಟೆಸ್ಟ್ ಡಿಸಿಷನ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬಂದಿದ್ ಮಾದ್ಮೇಲೆ I have no case, my lord.
With regard to the enhancement, my lord.
Death or injury?
Death case, my lord.
Death, my lord.
Okay.
Now, why
3509 is the date of accident.
Good.
3509.
Death ಯಾವಾಗ?
Death ಅವತ್ತೆ ಸ್ವಾಮಿ.
ಅವತ್ತೆ.
ಸರಿ.
Ravikumar, 33 years.
The deceased was pedestrian or?
ಇಲ್ಲ, ಈ ರೈಡರ್ ಆಫ್ ಎ ಮೋಟರ್ ಸೈಕಲ್.
Rider of motorcycle. What is the offending vehicle?
K09.
ಅಲ್ಲ, offending vehicle ಏನು class?
Goods, 3-wheeler goods auto rickshaw.
Goods auto. Charge sheet is against whom?
against the goods auto, my lord.
Against, yes. Exhibit P7, my lord.
Exhibit P7. Who are these witnesses? PW1 is the widow, is it?
Wife examined as PW1.
Who is PW2?
Is a sister.
I am a pillion rider of that motorcycle, deceased, her sister, his sister, my lord.
So she is the eyewitness.
Yes, my lord.
Pillion rider, eyewitness, my lord.
Who is this PW3?
Sister, a pillion rider.
PW3 is Channe Gowda. Who is the
PW3 is also eyewitness, my lord.
Witness.
eyewitnesses?
Also.
ಆಮೇಲೆ ಈ RW1 ರಘುನಾಥ್ ಸಿಂಗ್ ರಾಥೋರ್ who is
ಅವರು
the
ಓನರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್ ಮೈ ಲಾರ್ಡ್.
then
RW2 ಕಂಪನಿ ಆಫೀಸರ್.
So auto driver has not been examined.
ಅಲ್ಲ R1 is the
ಡ್ರೈವರ್
driver
ಕಮ್ ಓನರ್ ಸ್ವಾಮಿ ಅವರು.
RW1 was also driver.
ಡ್ರೈವರ್ ಕಮ್ ಓನರ್ ಸ್ವಾಮಿ.
He was driving at the time of the accident.
Exactly my lord.
And he is accused in the charge sheet.
ಹೌದು ಸ್ವಾಮಿ.
Correct?
Correct sir.
Please my lord.
So this accident you are not questioning, Allah?
ಇಲ್ಲ ಸ್ವಾಮಿ.
Negligence also
ಇಲ್ಲ ಅಂತ ಕ್ವಶ್ಚನ್ ಮಾಡಿರೋದು ಅಷ್ಟೇ ಇಶ್ಯೂ.
Okay.
Now on what ground you are seeking enhancement, Mr. Pramod?
My lord, the income which was taken is 3,000, my lord. Is a mason. According to the chart, my lord, in the year of accident is the 2009. It has to be taken 5,000, my lord. And with regard to the 4 dependents are there. One is wife, 2 others are the children, minor children, and 4th petitioner is the mother, my lord. 1/4 deduction has to be taken.
1/4 has to be no alwa.
1/4.
Correct swami. Wife, 2 minor children, father claimants.
1/4
deduction.
So age is kamdo age
33 years, my lord.
33 years, my lord.
Elli ಯಾವ page ಅಲ್ಲಿ ಇದೆ finding? Where do you get
in the judgment?
My lord, 9 page number 9 of the judgment. Loss of dependency and loss of estate is the middle para, my lord.
And age elli ideyappa?
Age, my lord, page 10, my lord. In the middle portion, the 5th line is there, my lord.
Yes. As per PME.
Yes, ma'am. Exhibit P6, my lord, PM report.
Age 33 ಗೆ multiplier ಎಷ್ಟು?
16, my lord.
16, my lord.
ಆದ್ರೆ PME ರಿಪೋರ್ಟ್
35 years ಅಂತ ಇದೆ ರೀ.
35 years ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
35 16 ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಮಲ್ಟಿಪ್ಲೈಯರ್ ಅದೇನಾ?
ಅದೇ ಬರುತ್ತೆ.
35 16 ಸ್ವಾಮಿ.
ಹಾಗಿದ್ರೆ ನಾನು 33 or 35 I will not get.
ಯಾವ್ದಾದ್ರೂ ಒಂದೇ my lord.
ಅಷ್ಟೇ. So 40%
loss of future prospect.
1750 ಆಗುತ್ತೆ. 5,000 plus 40%, 2,000, 7,000 ಆಗುತ್ತೆ ಟೋಟಲ್. 1/4 ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ರೆ 1750 ಮೈನಸ್ ಆಗುವಾಗ 4375 into 12 into 16 8,40,000.
ಅಲ್ಲ 5,250 ಬರುತ್ತೆ ಸರ್.
5,000 plus 40%.
2,000
7,000ದಲ್ಲಿ
minus 1/4 into 12 into 16. ಆಯ್ತಾ?
ಆಮೇಲೆ ಇವರು 5 ಜನ ಇದ್ದಾರೆ.
ಸಾರಿ 4 ಜನ.
1,60,000 plus 30,000.
Yes, madam.
1,90,000 ಇದು ಕನ್ಸಾರ್ಷಿಯಂ ಅಂಡ್ ಕನ್ವೆನ್ಷನ್.
Yes, madam.
ಅಲ್ವಾ?
ಹೌದು ಸರ್.
ಅಷ್ಟೇ
ಸರ್. ಬರ್ಕೊಡಿ.
These appeals are at the instance of the claimants and the insurance companies.
Calling in question
the correctness of the judgment and award dated 18/3/2011 in MEC 1383 of 2009 passed by so and so.
ಮುಕುಂದ್ ದೇವಾಂಗನ್ ಕೋಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಸರ್. ಮುಕುಂದ್ ದೇವಾಂಗನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. Please.
It is stated in the claim petition that on 3/5/2009 at about 12:15 p.m.
Ravi Kumar within bracket here
in after referred to as CTC bracket close, was riding his Hero Honda motorcycle bearing registration number K09 EJ 1100 with his sister Savita, within bracket, RW2, PW2 as pillion rider, and near Bata signal, the goods auto bearing registration number K09A3644, driven by its driver in a rash and negligent manner, came from behind and dashed into the motorcycle, and due to motorcycle, due to which the deceased and PW2 fell down and were dragged to some distance, and consequently he succumbed to the injuries. Before the learned tribunal, both the respondents entered appearance through their counsel and they filed their separate written statement denying the material elements made in the claim petition. Next part. During the trial, petition number 1, claimant number 1 was examined as PW1, and 2 eyewitnesses were examined as PW2 and PW3. Exhibit P1 to P10 were marked. Respondent number 1 before the tribunal examined himself as RW1, and one official of the insurance company was examined as RW2. Exhibit R1 to R8 were marked. Next further. After hearing the net counsel on both sides and appreciating the evidence, the tribunal allowed the claim petition in part and awarded a compensation of ₹4,67,000 with interest thereon at 6% per annum from the date of the petition till the date of payment. Next. Learned counsel for the insurance company in support of his appeal fairly submitted that in view of the decision of the Honorable Supreme Court in Mukund Devangan's case, the citation for it is not any longer open to him to question the validity and effectiveness of the driving license of respondent number 1, Raghunath Singh Rathore. Stop. However, he submits that there is no merit in the appeal filed by the claimant seeking enhancement of the compensation, as after comprehensive examination of the evidence placed, the tribunal has awarded just and reasonable compensation. Next one. In support of the appeal of the claimant, the counsel contended that the learned tribunal has awarded a lower compensation on account of it fixing a lower notional income for the deceased, and similarly, it has also awarded a lesser amount for the loss of consortium and conventional rate, and therefore the compensation awarded is required to be enhanced by allowing the appeal. Next one. I have given my anxious consideration to the submissions made on both sides and have carefully perused the record. Next one. Learned Tribunal has exonerated, Learned Tribunal, it has fixed the liability on insurance company, alwa?
ಹೌದು ಸ್ವಾಮಿ, ಅವ್ರ ಮೇಲೆ ಹಾಕಿದೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ.
ನನ್ನ ಮೇಲೆ ಲೈಬಿಲಿಟಿ ಇದೆ ಸ್ವಾಮಿ. That was questioned before this court.
Learned Tribunal has faced the liability to pay the compensation awarded by it on the insurance company. Insurance company has preferred this appeal on the ground that even though the insured vehicle was a light goods vehicle, light goods auto rickshaw, the driver of the said vehicle was in possession of another LMV.
My lord, non-transport endorsement illa.
Non-transport endorsement illa anta
was in possession of driving license without a non-transport endorsement. However, Learned Counsel does not dispute the fact that the class of vehicle for which the driver of the insured vehicle was having driving license was the same as the class of the offending vehicle. In that view of the matter, as held by the Honorable Supreme Court in Devangan's case, the insurance company cannot avoid the liability to pay the compensation. Accordingly, there is no merit in the appeal preferred by the insurance company and it is rejected. Next one. There is no dispute about the fact that at the time of the accident, deceased was aged 33 years. Therefore, appropriate multiplier applicable is 16. He has left behind 2 children, a widow and 1 parent. Therefore, under the head of spousal consortium, filial consortium and parental consortium, a sum of rupees 1,60,000 is required to be awarded and another sum of rupees 30,000 is required to be awarded under the conventional heads. Stop. Since deceased had died in the year 2009, his notional income has to be taken at rupees 5,000 as per the chart prepared by the Karnataka Legal Services Authority. Stop. In view of the decision of the Constitution Bench of Supreme Court in Pranay Sethi's case, citation, 40% of the established income is required to be added towards loss of future prospects. Full stop. Since he has left behind 4 dependents, 1/4 of his income has to be deducted towards personal expenses. Thus, the loss of dependency is recomputed as follows. It is 5,000 plus 40% minus 1/4 into 12 into 16 is to 1/4. Since the tribunal has already awarded rupees 4,67,000, the enhanced compensation is
7,31,000.
67,000 and minus the enhanced compensation. For the enhanced compensation, The appellant's claimants are entitled to interest at the rate of 6% per annum from the date of the petition till the date of payment. The appeal of the insurance company number of case dismissed. You will be allowed in part enhanced by points for with interest around. ಎಷ್ಟು ಟೈಮ್ ನಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಿ?
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
4 weeks my lord. 4 weeks my lord.
ನಿಮ್ದು ಡೆಪಾಸಿಟ್ ಇದೆಯಲ್ಲ?
ಇದೆ ಸ್ವಾಮಿ, ಸ್ಟೇ ತಗೊಂಡಿದ್ದೀವಿ, ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದೆ.
Deposit before this court shall be transmitted to the MAC.
Number 90, Lingraj. HS Lingraj.
Appear for second respondent, my lord.
Lingraj appear.
Second respondent, my lord.
HS Lingraj.
Second respondent ಯಾರು? ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರ ಯಾರು?
Your lordship, I appear for second respondent. EI Sanmati, my lord.
Okay, okay.
In the first case, my lord. Second case ನನಗೆ ಬಂದಿಲ್ಲ ಅದು.
ಅದು ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ? ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು.
ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು ಹಾಕಿದ್ದಾರೆ ಸೊಮ್ಮೆ ವಕಾಲತ್ತು.
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು?
ಅವರು ಇಲ್ಲ.
ಲಿಂಗರಾಜ್ ಇದ್ದಾರಾ?
ಲಿಂಗರಾಜ್ ಅವರು ಇಲ್ಲ ಸ್ವಾಮಿ.
ಏನು ಡೆತ್ ಸನ್ಮತಿ ಅವರೇ, ಏನಿದು?
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ಇನ್ ದಿಸ್ ಕೇಸ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಲಯಬಿಲಿಟಿ ಇರ್ಲಿಲ್ಲ, ಓನರ್ ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು. ಓನರ್
ಇಂಜುರಿನಾ ಡೆತ್?
ಇಂಜುರಿ ಕೇಸ್ ಲಾರ್ಡ್. Owner had filed the MFA number 651 of 2012 and 650 of 2012. It has been held that insurance company is liable. ಇದರಲ್ಲಿ ಬರೀ ಕ್ವಾಂಟಮ್ ಮಾತ್ರ ಇದೆ ಸ್ವಾಮಿ ಈ ಎರಡು ಕೇಸ್ ಅಲ್ಲಿ. ಓನರ್ ಹಾಕಿದ್ದು MFA 651 of 2012 and 650 of 2012.
ಯಾವಾಗ ಡಿಸ್ಪೋಸ್ ಆಯಿತು?
ಅದು 24/7 ಸ್ವಾಮಿ.
ಯಾವ ಇಯರ್ ಸರ್ ಡಿಸ್ಪೋಸಲ್?
24/7
ಇದೇ ವರ್ಷನಾ?
ಇದೇ ವರ್ಷ
2021. ಯಾವ ಇಯರ್ ಡಿಸ್ಪೋಸಲ್?
One your lordship, I will 651 of 2012. Lordship, your lordship, it has been decided on 24/7/2019.
ಯಾಕೆ ಅವನ್ನೆಲ್ಲ ಕ್ಲಬ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದಿಲ್ಲ ಆಗೋಕೆಲ್ಲೇ?
Your lordship, I was not aware about this pending cases, my lord. And Honorable Justice, my lord, Lordship, Honorable Justice K. Somashekhar, my lord, on 24/7/2019 allowed the appeal, my lord, by holding that insurance company is liable to pay. And it is a common judgment, my lord, 651 and 652, my lord. And the insurance company was directed to deposit the award amount within 6 weeks, my lord.
ಅದೇನಾಯ್ತು? ಅದು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಾ?
ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಸ್ವಾಮಿ. It is only 15,000 the lower court award, my lord.
ಎರಡರಲ್ಲೂ 15,000.
I am having only one appeal memo, my lord. In first case, it is 15,000, my lord.
ಇದು ನಮ್ಮ ಅಪೀಲ್ ಮೆಮೊ ಕೊಡ್ರಿ. ಎರಡು ಅಪೀಲ್ ಮೆಮೊ ಕೊಡ್ರಿ. ಇದೇನು ವರ್ಕ್ ಕೊಟ್ರಿ, ನೆಕ್ಸ್ಟ್ ಕೊಟ್ರಿ ನೀವು 90. ಇನ್ನೊಂದು 7488. ಒಂದರಲ್ಲಿ 10,000, ಇನ್ನೊಂದ್ರಲ್ಲಿ 15,000. ನೀವು ಮನು ಕ್ಲೇಮೆಂಟ್ ನಿಮ್ದು ಸನ್ಮತಿ?
Yes, my lord. Manu, my lord. In my case, it is Manu, my lord.
ನಿಮ್ದಲ್ಲಿ ಮನು.
Manu.
ಮನು ಇಂದು 15,000, ಇನ್ನೊಂದ್ರಲ್ಲಿ 10,000.
10,000.
ಆಯ್ತು. ಏನು ಇಂಜುರಿ?
Your lordship, ಅಲ್ಲಿ your lordship, all simple injuries, my lord. Occipital region 3 x 3 centimeter, abrasion over left side of abrasion 3 x 5 centimeter ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಿಂಪಲ್ ಇಂಜುರೀಸ್ ಇದೆ.
ಎರಡರಲ್ಲೂ ಸಿಂಪಲ್ ಇಂಜುರಿಗಳಲ್ಲ?
ಎರಡರಲ್ಲೂ ಸಿಂಪಲ್ ಇಂಜುರೀಸ್. It is 2011 case, my lord. From last time also they have not appeared. They have been simply dragging the case, my lord.
ಆಯ್ತು, ನಾವು ಡಿಸೈಡ್ ಮಾಡೋಣ.
Please.
ಏನು ಅವ್ರಿಗೆ ಅವರು ಬಂದು ಹಿಯರ್ ಮಾಡಿನೂ ಏನಾಗುವಂತದಿಲ್ಲ. ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ, ಹಾಗಾಗಿ ಇರ್ಬೇಕು. ಅದು ಸಿಕ್ತಾ? P6 ಮತ್ತೆ P12 ಯೂಸ್ ಮಾಡಿ. These two appeals are at the instance of the claimant seeking enhancement of the compensation awarded by common judgment and award dated 14/6/2011 in MEC 3057 and 3058 of 2010, passed by Leonard so. ಇದು ಮತ್ತೆ ಇಲ್ಲಿ next in the by the impugned judgment and award, claimant appellant Nagesh MEC 3057/2010 was awarded a total compensation of 10,000, and claimant Manu MEC 3058/2010 was awarded a total compensation of 15,000. Next.
learned counsel also, the learned counsel from the insurance company informs me that the common judgment and award in this case was challenged by the owner of the vehicle in MFA number 651 and 650 of 2012, calling in question the direction in the award, imposing liability to pay the compensation on him, and the appeals were allowed by a common judgment dated 24/7/2019 by this court, basing the liability to pay the aforementioned compensations on the insurance company. Next one. A detailed reference to the facts of the case is not necessary for disposing of this appeal. Exhibit P6 is a wound certificate in respect of appellant Nagesh, and Exhibit P12 is a wound certificate in respect of appellant Manu. Appellant Nagesh has suffered the following injuries. Exhibit P6 is issued by Niman's Hospital, Bangalore. The injury is stated to be simple in nature. Similarly, Exhibit P12 issued by BGS Global Hospital, Bangalore shows that Manu had suffered the following injuries. The injury suffered by Manu is stated to be grievous in nature. Based on the medical bills produced, the Net Tribunal has assessed the compensation to be awarded at rupees 10,000 for Nagesh and rupees 15,000 for Manu. There is no good ground made out to grant enhancement of the compensation awarded by the Net Tribunal. Accordingly, there is no merit in these two appeals, and they are liable to be dismissed. Hence, the following: they are to appeal dismissed.
Your Lordship, liability has to be shifted, my lord.
So that has been shifted already.
In this case also it requires to be followed, my lord. Because
Same judgment, same judgment.
Please, my lord, please.
Note ಮಾಡಿದ್ದೇನೆ ಅದನ್ನು.
Okay, please, my lord. Much obliged, my lord.
In the owner's appeal, liability has already been shifted.
Please, my lord. Much obliged, my lord.
91, BL Sanjeev.
This case
91.
I'm for
the respondent, my lord.
I'm for appearing petitioner, my lord. Kindly pass over the matter, my lord. Senior was stuck in another court.
4:30 now it is. Pass over.
Senior was stuck in another court, my lord. Kindly pass over the matter.
I am ready, my lord.
Mr. Sanjeev, you appear for whom, claimant or KSRTC?
KSRTC, my lord. KSRTC.
KSRTC. You appear for the workman, is it, madam?
Yes, my lord.
ನಿಮ್ಮ ಹತ್ರ ಫೈಲ್ ಇದೆಯಾ ಮಿಸ್ಟರ್ ಶ್ರೀನಿವಾಸ್?
No, my lord. My senior was stuck in another court. Kindly pass off a few minutes.
ನಾನು ಅವರನ್ನೆಲ್ಲ ಕೇಳಿದ್ದು, ನಿಮ್ಮ ಹತ್ರ ಫೈಲ್ ಇದೆಯಾ ಶ್ರೀನಿವಾಸ್?
ಇದೆ my lord.
ಇದೆಯಾ? ಸ್ವಲ್ಪ ಓಪನ್ ಮಾಡಿ. ಡೋಂಟ್ ವರಿ. Don't worry. I will. So this claimant was a conductor.
Yes, ma'am.
With you? ಏನು ಬರ್ನ್ ಇಂಜುರಿ ಆಯ್ತಾ? ಏನಾಯ್ತು?
Fracture of both bones of right leg. Fracture of both bones of right leg.
No, madam, because his senior is not here.
Yes.
I want some assistance from you.
Yes, ma'am.
What is the case of the KSRTC?
KSRTC has challenged the award on the ground. The disability assessed by the commissioner is on higher side. That is against the exhibit R through. That is medical board has assessed only 35%, but commissioner has taken as 45%. That is not correct. That is their case.
So,
and he has been.
One ನಿಮಿಷ. ಅಂದ್ರೆ employer-employee relationship ಎಲ್ಲ ಏನು dispute
No dispute.
It is only questioning the quantum.
Yes, ma'am. Quantum, and their case is though they retained him in his bad job, that he was alternative job was given as B, helper B. In spite of it, he is not entitled for compensation. That is their case. Earlier, my lord, the case was allowed in the year 2003, and 1,99,661 was awarded with 12% interest.
How can you find fault with his contention, KSRTC contention?
Yes, my lord.
Loss of earning capacity only under Workmen Compensation Act.
Yes.
Compensation can be given.
Yes, ma'am.
No other ground.
Exhibit P5 is the certificate issued by the same hospital, SNR hospital.
Madam, you have not followed.
Yes.
It is not, there is distinction between
yes.
the basis for awarding compensation under MB Act and under the Employees Compensation Act.
Yes,
under Employees Compensation Act, a compensation can be awarded only on proof of loss of income due to the employment-related accident.
Yes.
In this, they have mitigated the whole thing. Nobody can deny the fact that your client has suffered a fracture or a physical disability. But functional disability and consequent loss of income has been offset by them by providing an alternative employment under them only.
No, their case, my lord, they are not denying that he is not entitled for compensation. Law is, though that person is retained in the job, though he was promoted, he is entitled for compensation under the act. That is the law. I am relying on judgment of this honorable court.
Under this employees compensation.
Yes.
Yes. Which is that, madam? Which is that?
ILR 2007, Karnataka, page number 3482.
Party is really.
Party is the general manager versus Tungabhadra Minerals Limited versus Sri G. Amir. General manager measures Tungabhadra Minerals Limited versus Sri G. Amir.
Amir.
Yes, G. Amir. So many judgments are there, my lord. Gola Rajanna and the Supreme Court judgment is there.
Supreme Court is there.
Supreme Court do substantial question of law ಅಲ್ಲ. Percentage of disability assessed by the commissioner is a finding of fact. It does not amount to a substantial question of law. That is AR 2016 Supreme Court page number 5382. Golarajanna versus Divisional Manager and another etc. Order of High Court regarding its own finding on percentage of disability and reducing compensation awarded by reappreciating evidence liable to be set aside. On the ground, it is not a substantial question of law. That is a finding of fact recorded by the commissioner. Yes, even unreported judgment is also there, my lord. That is computation case. Computation case, my lord, that is not reported. That is 5th November 2012. It was disposed of.
Now kindly point out.
Yes, ma'am.
The para where this is discussed in Amir case.
ILR para 10, your lordship's
Para 10. A perusal of the
referred report decisions reveals the certain distinction has to be made between the loss of earning and loss of earning capacity. Entitlement to compensation is not lost merely on account of retention and even of promotion in the same establishment. The entitlement to compensation under the Act cannot be denied or postponed depending on the present or future earning. The total amount that a workman can get is fixed by the Act. The same depends upon the difference between his wage earning capacity before the accident and his wage earning capacity after the accident. The provisions of beneficent legislation are to be construed so as to advance the beneficent purpose. Para 11. In view of the aforesaid discussed righty position in law, the formidable contention urged on behalf of the appellant fails. This appeal is dismissed. Same contention was taken in this appeal also, my lord. That is by the employer appeal. They have taken contention. He has been retained in the job by giving alternative employment.
Madam, what you are reading out exactly is in accordance with your contentions.
Yes, my lord.
No
That
doubt
is
about
also
it.
one more judgment.
I remember to have read some Supreme Court judgment.
Yes, yes.
It is contrary.
Palras case. In that case, my lord, Palras case, Supreme Court judgment. In that case, my lord, he has 100% disability was taken. So that he has been reduced on the ground that he has been given some other job in that company or establishment. Palras case. He is entitled for the compensation, but what is the percentage that is important? In this case, conductor, he gets so many promotions. He has lost all the benefits, my lord. Promotion, OT, and so many benefits are there in conductor job. But helper B is concerned, he lost so many benefits. And that apart,
in this, he was not given promotion.
Promotion is in that cadre, that is the helper cadre, not in conductor post.
What is the
salary is also more in conductor post, and benefits giving, that is traveling allowance, ante matte OT, so many things he used to get if he is a conductor. And the doctor has given certificate, same hospital.
This correct designation ಏನು ಅವನಿಗೆ?
ಈಗ ಬಿ ಹೆಲ್ಪರ್ ಕೇಡರ್ ಅಂತ, ಬಿ ಹೆಲ್ಪರ್ ಕೇಡರ್ ಅಂತ ಅದೇ ಅದರಲ್ಲಿ assistant. Yes, they have produced exhibit R1. You lordship may find this. That is their document. Exhibit R.
I need to hear Mr. Sanjeev also in this case. Palraj case ನಿಮ್ಮ ಹತ್ರ citation
ಇದೆ Palraj ಇದೆ, but so many judgments are there, my lord. That is ಇದು Palraj ಬಂದು SCC 2010 volume 10. Volume
Anyway.
10, page number 347.
No, I will do one thing. Shri B.L. Sanjeev is not present. His learned junior counsel submits that he is held up in.
My lord, I appeal for the. My apologies, my lord. I was up in another court.
You are Mr. Sanjeev?
No, my lord, I'm his colleague. I will be arguing the matter. My lord, this is being covered by the apex court. My lord, I have also issued.
Which is the decision?
My lord, Pal Raj versus DC, any case RTC, my lord. That has been followed by our High Court also in WP number, MFA number 11258 of 2007, my lord.
When is that?
I requested the court officer to get a copy of this order, my lord.
I'll do one thing.
Yes, my lord. Idರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ my lord, they have only ready.
When shall I take up?
My lord, anytime I will produce this copy.
Learned counsel on both sides to submit their brief notes of argument in bullet point manner, and also submit their list of authorities. Honor, can you file it with my court officer?
Yes, my lord, I will do it.
Wednesday?
Yes, my lord, I will do it.
When can you?
My lord, I will do it tomorrow itself, my lord.
Your lordship will kindly have it next week, because next week onwards.
When will you give, madam? I will give the earliest date, no problem. When will you give?
Judgments, my lord, by Tuesday or Wednesday. Pal Raj case is available, but there are other unreported judgments.
ಅವೆಲ್ಲ ಏನೆಲ್ಲ ಕೊಡ್ಲಿಕ್ಕಿದೆಯಾ ಅದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಮೇನ್ ಬರ್ದ್ರಿ ಮೇಡಮ್. Please listen. Learned counsel on both sides to submit their brief notes of argument in bullet point manner, and also submit their authorities, list of authorities, on or before Tuesday or date.
Tuesday beda. Wednesday or Thursday, your lordship may kindly say.
I will take up for hearing on the next day. So it will put up before.
Wednesday, your lordship may kindly say. Wednesday. By Wednesday, ಯಾಕಂದ್ರೆ ಇದು.
By Wednesday, ಅಂದ್ರೆ ಯಾವ ತಾರೀಕು? 9. List the matter for hearing on 10. ನೀವು ಇಲ್ಲಿ ನಮ್ಮ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಕೊಡ್ಬೇಕು ಇಬ್ರು.
Yes, my lord, I will.
ಮತ್ತೆ ನೀವು ಲೇಟ್ ಆಗಿ ಕೊಟ್ರೆ ಅದರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಗುತ್ತೆ.
Even arguments also, my lord, only authorities or arguments.
ನೀವು ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಓದ್ಕೊಳ್ಳಿ. Everything will be there in the website. Today
I apologize, my lord.
Number 92, O Mahesh.
Appellant, lord.
Where is Kavita HC?
ಹೌದು, ಕವಿತಾ ಹೆಚ್ಚಿಗೆ ಬಟ್ ಅವ್ರು ಜೂನಿಯರ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
You appear for Kavita HC?
ನಿಮ್ದು ಮ್ಯೂಟ್ ಆಗಿದೆ ಮೇಡಮ್. ಕವಿತಾ ಹೆಚ್ಚಿ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಕವಿತಾ ನಂಬರ್ 92, ಓ ಮಹೇಶ್.
I appear for appellant.
There is some problem from your side, Madam Kavita. Some problem in your system. ಹೇಳಿ ಅದು ಯಾಕೆ ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲೇ ಅವ್ರದೇ ಪ್ರಾಬ್ಲಮ್ ಮೇಡಮ್. ಕವಿತಾ ಮೇಡಮ್.
Hearing mala. Physical hearing. My lord, I pray for physical hearing. Physical hearing. I pray for physical hearing.
Why physical hearing, madam? Today, of course,
Next
I can grant you
week.
time because there is some problem with your
Next
system.
week.
I can't hear. Mr. Mahesh, what is the substantial question?
Brad, the liability, my lord. Tractor trailer, agriculture tractor trailer, admittedly had
My lord, can I appear before your lordship? Court hall.
Not now, when there is a SOP issued by the High Court which says physical appearance is not permitted.
7th they can do it. From 7th they can do it.
7th ಅಂದ್ರೆ ಈಗಾಗಲೇ ಬಂದಿದೆಯಾ?
ಬಂದಿದೆ ಸರ್.
ಮಂಡೇ ಇಂದ ಫಿಸಿಕಲ್ ಇದೆ.
ಮಂಡೇ ಆಯ್ತು. Learned Council 7th ಇಂದ ಅಂತ ಫಿಸಿಕಲ್ ಅಪಿಯರೆನ್ಸ್ ಬಹಳ ಸ್ಪ್ರೆಡ್ ಆಗ್ತಾ ಇದೆ.
7th is all right.
7th ಹಾಕೋದಿಲ್ಲ ನಾನು. 7th ಆಲ್ರೆಡಿ ಈಗ ಹಾಕಿದ್ ಬಹಳ ಇದೆ. 10th ಹಾಕಿ ಆಯ್ತು. 10th Mr. Mahesh, see in the website, date will be there.
93 urgent, 94.
Learned Council on both sides.
No, I appear for appellant in the case.
I appear for respondent. I appear for respondent in this case, my lord. Idu 163 am aitilla. Connected matter I appear for appellant.
94, 93 ಬೆಳಗ್ಗೆ urgent 94. ಎಲ್ ಶ್ರೀಕಂಠ ರಾವ್.
93 ಯಜನ್ ಆಗಿದೆ ಅಂತ ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ದಾರೆ ಕಾಣ್ತದೆ.
ನಾವು 94 ಸಮಯ ಹೇಳ್ತಾರೆ.
94.
ಶ್ರೀಕಂಠ.
I appear for appellant. Appellant in 8,301.
Appellant in 788.
Harish Babu, you are for the claimant?
Claimant, my lord.
Claimant.
Idu 163 as well. No fault liability ಕೊಟ್ಟಿ 50,000 163 ಅಲ್ಲಿ my contention is multiplier ತಗೊಂಡು ಕೊಡಬೇಕು ಅಂತ ಅಷ್ಟೇ. As per 163 schedule 2 ಪ್ರಕಾರ multiplier ತಗೊಂಡು ಕೊಡಬೇಕಿತ್ತು. 50,000 ಕೊಟ್ಟಿ ಸರಿ ಇಲ್ಲ ಅಂತ.
May I submit?
Yes, sir.
Challenge the insurance appeal challenges the liability to pay the compensation. The date of accident is 2/8/2009. 2 vehicles are involved in the accident. 2 motorbikes. One is insured with the appellant. The other vehicle did not possess any insurance policy at all. As far as my insured vehicle is concerned, it was entrusted to some other person.
This deceased was rider or pillion rider?
Deceased was a rider. 2 vehicles are involved.
ಅದೇ ನಾ ಕೇಳ್ತಾ ಇರೋದು. ಅವನ ವೆಹಿಕಲ್ ನಲ್ಲಿ
He was a rider of the vehicle.
Rider. Now claim is made against the insurer of
insurer.
His insurer.
That's not maintainable.
He is not
third party. He steps into the shoes of the Ramkilad case.
ಅದು 2-3 ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಬಾಲಕೃಷ್ಣನ ಸುಧಾಕರನ್.
ಅದೆಲ್ಲ ಅದು ಸುಧಾಕರನ್ ಎಲ್ಲ ಬರೋದು ಇದು ಈ ಪಾಲಿಸಿ ಕಾಂಪ್ರಹೆನ್ಸಿವ್ ಪಾಲಿಸಿ ಅಂಡ್ ಆಕ್ಟ್ ಪಾಲಿಸಿ. ಆಕ್ಟ್ ಪಾಲಿಸಿ ಕೆಳಗಡೆ ಇದು ಬರ್ತದೆ. ಸುಧಾಕರನ್ ಅಂತೆಲ್ಲ ಬರುತ್ತೆ. ಇದು ನನ್ನ ಕಂಟೆನ್ಷನ್. ಇದು ನಂದು ಪಾಲಿಸಿ ಇತ್ತು. The deceased steps into the shoes of the owner. As such, a claim petition as against the insurance company is not maintainable in respect of my insured vehicle rider.
Yes, ಯಾವುದು ಡಿಸಿಷನ್ ಯಾವುದು?
Ramkilad 2020 to Supreme Court 550. 2020 to Supreme Court cases 550.
So both rider and pillion rider both have met with death, is it?
Pillion and ಎರಡು riders of both the vehicles died.
Both making a claim against the same insurance.
ನನ್ನ ಕಂಪನಿ ಮೇಲೆ ಇಬ್ರು ಹಾಕೊಂಡಿದ್ದಾರೆ. The other vehicle did not possess the insurance policy at all.
But so far as the other is concerned, how can you dispute?
The said vehicle did not possess an insurance policy at all.
ಅವನು ಬಿಟ್ಬಿಡ್ರಿ ನೀವು ನಿಮ್ಮದಕ್ಕಿತ್ತಲ್ಲ ಇನ್ಶೂರೆನ್ಸ್
ಅಲ್ಲ ನಂದಕ್ಕೆ ಸೊಮ್ಮೆ ಆದ್ರೆ
Mr. Shrikant Rao, so far as your rider is concerned, you are relying on Ram Khiladi, whatever. See, he steps into the shoes of the owner.
Sure.
That is insured. Therefore, he can't make a claim against his own this.
Yes.
But so far as the other rider is concerned, by the use of your vehicle also, it is there. So 163A, how can you resist?
In this case, Your Lordship, kindly note that both the riders of the vehicle who died have been charge sheeted. An abated charge sheet is filed by
163A ಗೆ ಅದು ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅಲ್ಲ.
163. It's true, Brad. I do have the recent judgment, but three judges, which are Supreme Court judgment. What is the one nimsham? New India Assurance Company versus Chandrakant Tiwari versus New India Assurance Company. Chandrakant Tiwari versus New India Assurance Company. Decided on 8/6/20. ಮೇಡಮ್ ಇದು ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಇದರಲ್ಲಿ ನಂದು SCR ಅಂತಿದೆ ಇಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ SCR ಅಲ್ಲಿ ಇದರಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ SCC ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ
ಆಯ್ತು ನಾವು ನೋಡೋಣ ರಾಮ್ ಖಿಲಾಡಿ ಯಾವ್ದದು
ರಾಮ್ ಖಿಲಾಡಿ 2022 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸಸ್ 550 2020 within brackets 2 volume 2 Supreme Court cases 550.
550.
Yes.
Chandrakant Tiwari.
Equivalent three judges ಕೊಡ್ತೀನಿ ಸರ್ ಒಂದು ನಿಮಿಷ ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ ಸರ್
ಇದರಲ್ಲಿ can I submit?
ಯಾಕೆ ನಾನು ನಿಮ್ಮನ್ನು ಕೇಳ್ತೇನೆ
ಪ್ಲೀಸ್
that Mr. Shrikant Rao, Chandrakant Tiwari is reported in 2020. 7 SEC, page 386. So because of Chandrakant Tiwari, you have no case so far as the other motorcycle is concerned. That is for sure.
Yes, I do.
ಅದೊಂದು ಕಾಪಿ ತೆಗೆದಿದ್ದೀಯ ರಾಮ್ ಖಿಲಾಡಿ what does Ram Khiladi now say?
Para 5:1 and 5:2 ಅದು ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ರಾಮ್ ಕಿಲಾಡಿಯಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತಂದ್ರೆ no fault liability of insurer. Insurer liable only to the third parties and not to the owner of the vehicle who himself involved in the accident. Borrower of the vehicle steps into the shoes of its owner. In the instant case, deceased by driving the borrowed vehicle suffered an accident with the offending vehicle. No claim made against the against owner and insurer of the offending vehicle. Claim against the owner and insurer of the borrowed vehicle not maintainable. Para 5:1 and 5:2.
5:1 and 5:2.
Para 5. Para 5:4 and 5:5.
Uh, 5.4 ಅಲ್ಲ ನೀವು ಹೇಳಿದ್ದು
4, 5 and 6.
That 5.4 that in the present case the deceased was not a third party given that he had borrowed the vehicle from the registered owner Shri Bhagavan Sahai Meena. In Ningama versus United India Insurance Company Limited and Sadanand Mukhi, owner of the vehicle or its legal representative or the borrower of the vehicle cannot raise a claim for an accident in which there was no negligence on the part of the insured vehicle. It is submitted that in the aforesaid decision, this court has held that the vehicle steps into the shoes of the owner and therefore the borrower of the vehicle or its legal representative are not entitled to compensation from the insurer. That the deceased in the present case has stepped into the shoes of the owner and therefore not entitled to any third party compensation for the insured vehicle.
Next para negligence ಬಗ್ಗೆ ಮಾಡಿದ
covers the liability insured incurred by the in respect of death or bodily any person carried in the vehicle or the damage to the property of a third party caused by or arising out of it. Mr. Harish Babu, have you gone through Ram Khiladi judgment?
ಹೌದು ಸ್ವಾಮಿ ನೋಡಿದ್ದೀನಿ ಅದರಲ್ಲಿ they have not dismissed the case.
Yes, what have they done?
At next continuation, however, at the same time, even as per the 5.8 ಅಲ್ಲಿ as per the contract of the insurance, in case of personal accident, the owner driver is entitled to a sum of rupees 1 lakh. Therefore, ಇದರಲ್ಲಿ ಫೈನಲ್ ಆಗಿ ಫೈನಲ್ ಡಿಸಿಷನ್ ನೋಡಿ ಸರ್, ಫೈನಲ್ ಪ್ರೇಯರ್
ಆಯ್ತು.
ಲಾಸ್ಟ್ ಅಲ್ಲಿ
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ?
ಲಾಸ್ಟ್ ಬಟ್ ಒನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಟ್ ಈಸ್ 5.8 ಅಲ್ಲೇ
5.8 ಅಲ್ಲ
5.8 ಅಲ್ಲೇ
ಅದು ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್
ಒಂದು ನಿಮಿಷ
ಇದ್ರೆ ಕೊಡ್ಬೇಕು ಅಂತ
ಸರ್. ರಿಗಾರ್ಡಿಂಗ್ ಫಸ್ಟ್ ಕೇಸ್ ಬಗ್ಗೆ ನಾನು ಮಾಡ್ತಾ ಇರೋದು 5.8 ಅಲ್ಲಿ ಆಫ್ಟರ್ ಕನ್ಸಿಡರಿಂಗ್ ದ ಡಿಸಿಷನ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್ in Oriental Insurance versus Jumsha.
You are reading Mr. Harish Babu, you are reading Ram Khiladi or
Ram Khiladi. Ram Khiladi. 5.8 ಅಲ್ಲಿ.
Okay. 5.8. However,
ಇಂದ ಅಲ್ಲಿಂದ ನೆಕ್ಸ್ಟ್ ಇದರಲ್ಲಿ ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ವರ್ಸಸ್ ಜಿಮ್ನಾಸ್ಟಾ ಆಫ್ಟರ್ ಕನ್ಸಿಡರಿಂಗ್ ದ ಡಿಸಿಷನ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್.
however, at the same time, even as per the contract of insurance, in case of personal accident, the owner driver is entitled to a sum of rupees 1 lakh. Therefore, deceased as observed here in above, who would be in the shoes of the owner, shall be entitled to a sum of rupees 1 lakh. Contract of insurance. However, it is the case of in the contract of insurance in this, is there such a provision of 1 lakh?
Yes, ಇದೆ.
Exhibit P1 ನಾವು R1 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ, ಪಾಲಿಸಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀವಿ. ಅದ್ರಲ್ಲಿ ಇಲ್ಲದೆ ಇದ್ರೆ ನಾನು ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ನನ್ನ ಐ ಕ್ಯಾನ್ ಸಬ್ಮಿಟ್ ಟು ದ ಕೋರ್ಟ್ ಬೈ ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ. ಎಷ್ಟು ಕವರೇಜ್ ಬರುತ್ತೆ
ಇಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ R1 ಎಲ್ಲಿದೆ?
ಎಕ್ಸಿಬಿಟ್ R1 ಇದೆ, ಅಲ್ಲಿ ಇಲ್ಲದೆ ಇದ್ರೆ ನಾನು ಮಂಡೇ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ. ಎಷ್ಟು ಕೊಡ್ತೀವಿ, ಎಷ್ಟು ಕೊಡ್ಬೋದು?
1 lakh ಇದೆ ಸ್ವಾಮಿ.
PA ಕವರ್ಗೆ?
ಹೌದು, PA ಕವರ್ಗೆ 1 lakh ಇದೆ. ಕೆಳಗಡೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್ಸ್ ಕವರ್ ಫಾರ್ ಓನರ್ ಡ್ರೈವರ್ CSI rupees 1 lakh.
ಎರಡನೇ ಪೇಜ್ ನಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ, ಎರಡನೇ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಕೆಳಗಡೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ ಇದೆ.
ಇಂಪಾರ್ಟೆಂಟ್ ನೋಟಿಸ್.
ಲಿಮಿಟ್ಸ್ ಆಫ್ ಲಯಬಿಲಿಟಿ.
If the vehicle is used or driven otherwise than any.
That's the limits for liability under section 2(1) death ಅಂತ ಇದೆ.
Limits of liability.
Other last personal accident cover of owner driver 1 lakh.
ಅಂದ್ರೆ ಪರ್ಸನ್ಸ್ ಆರ್ ಕ್ಲಾಸಸ್ ಆಫ್ ಪರ್ಸನ್ಸ್ ಎಂಟೈಡ್ ಟು ಡ್ರೈವ್ ಅಂತ ಇದೆ. ಅದರ ನೆಕ್ಸ್ಟ್
ಲಿಮಿಟ್ಸ್ ಆಫ್ ಲಯಬಿಲಿಟಿ ಅಂತ ಇದೆ.
ಓದಿ ಅದನ್ನು. ಲಿಮಿಟ್ಸ್ ಆಫ್ ಲಯಬಿಲಿಟಿ ಏನಂತ ಇದೆ? ಓದಿ ಕಂಪ್ಲೀಟ್.
ಡೆತ್ ಆಫ್ ಆರ್ ಬಾಡಿಲಿ ಇಂಜೂರ್ಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಎನಿ ಒನ್ ಆಕ್ಸಿಡೆಂಟ್ ಆಸ್ ಪರ್ ಮೋಟರ್ ವೆಹಿಕಲ್ ಆಕ್ಟ್ ಆಫ್ 1988 ಅಂಡರ್ ಸೆಕ್ಷನ್ 2-1 damage to third party property in respect of any one claim or series of claim arising out of one event 6 lakhs. Personal accident cover
ಅಲ್ಲ rupees ಅದು 6000 ಅಂತ ಇದೆ.
6000 ಸಾರಿ 6000 ಕೆಳಗಡೆ ಪ್ಲೀಸ್
ಕೆಳಗಡೆ ಇದೆ.
ಅದ್ರ ಕೆಳಗಡೆ ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಕವರ್ ಫಾರ್ ಓನರ್ ಡ್ರೈವರ್ 1 lakh.
ಕೆಳಗಡೆ ಇಲ್ಲವಲ್ಲ ಇದರಲ್ಲಿ?
ಹೌದಾ, ನಮ್ಗೆ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಇದೆ
ನೋಡಿ. ಅದರಲ್ಲಿ ಹೆಸರು ಯಾರ್ದಿದೆ? PR ಅನಿಲ್ ಕುಮಾರ.
ಹೌದು ಸ್ವಾಮಿ, PR ಅನಿಲ್ ಕುಮಾರ್.
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡ್.
ನೀವು ಹೇಳಿದ 1 ಲಕ್ಷ.
ಪ್ಲೀಸ್ ಬನ್ನಿ.
This is HH Splendor.
ಹೌದು ಸ್ಪ್ಲೆಂಡರ್ AP 03P42831.
ಪರ್ಸನಲ್ ಇದರಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ ನನ್ನಲ್ಲಿ.
ಕೊಟ್ಟಿರೋ ಪಾಲಿಸಿದಲ್ಲಿ ಇದೆ.
ಅದನ್ನ ನೀವು ಝೂಮ್ ಮಾಡಬಹುದಾ? so that Mr. Shrikant Rao can see. Zoom ಮಾಡಬೇಕು.
Zoom ಮಾಡೋದು. ಮಾಡಿ ಕಳಿಸ್ತೀನಿ.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಪಾಲಿಸಿ ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಕವರ್ ಇದ್ರು ದ ರೈಡರ್ ಡಿಡ್ ನಾಟ್ ಪೊಸೆಸ್ ಎ ಲೈಸೆನ್ಸ್ ಅಟ್ ಆಲ್. ಅದು ಅಡ್ಮಿಟೆಡ್ PW1 ಹೇಳಿದ್ದಾರೆ. ಲೈಸೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ ನಮ್ಮ ಹತ್ರ, ನಮ್ಮ ಹಸ್ಬೆಂಡ್ ಹತ್ರ. ಅವ್ರ ಎವಿಡೆನ್ಸ್
ನೀವು ಪೇ ಅಂಡ್ ರಿಕವರ್ ಮಾಡ್ಬೇಕಾಗ್ತದ ಅವಾಗ.
ಅಲ್ಲ ಅವನೇ ಓನರ್ ಆಗ್ತಾರಲ್ಲ, ಅವರೇ ಹೇಳಿದ PW1 ಹೇಳಿದ್ದಾರೆ.
ಹರೀಶ್ ಬಾಬು, ನಿಮಗೆ ಲೈಸೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ.
ಮತ್ತೆ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಲ್ಲ, ಇದು ಆ ತರ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇದು ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಗೆ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ನಿಮ್ಮದೇ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ನೆಟ್ ಇಫೆಕ್ಟ್ ಏನು? ಪೇ ಅಂಡ್ ರಿಕವರ್. You are the claimant, you pay yourself.
ಅಲ್ಲ, ನಾವು ಓನರ್ ಅಲ್ವಲ್ಲ. ಓನರ್ we are stepping to the
you see what the Supreme Court has said in that para that you are placing reliance on, that you step into the shoes of the owner.
Owner ಅಷ್ಟೇ.
So when you step into the shoes of the owner, you ask your owner.
Owner
ಎಲ್ಲ ಅವ್ರಿಗೆ ಅವ್ರ ಎವಿಡೆನ್ಸ್ PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿ ಓದ್ಬಿಡಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ, ನಾವೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೋತಾ ಇದೀವಿ, ಅದನ್ನ ಓದೋದೇನಿದೆ ಸರ್? ಓದ್ಬೇಕು. ನಾವು ಓನರ್ DL ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಓದ್ಬೇಕು. DL ಇದೆ ಅಂತಾರೆ, ನಾವು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೋತಾ DL ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೆ. ಬಟ್ ಏನಂದ್ರೆ 163 ಅಲ್ಲಿ DL ಅನ್ನೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ಪ್ರೊಡ್ಯೂಸ್ ನೆಸೆಸರಿ ಸೈಟೇಷನ್ ಆಲ್ಸೋ ರಿಗಾರ್ಡಿಂಗ್ ದಟ್ ಆಲ್ಸೋ.
ಯಾವ್ದು ಬೇಕು ಹೇಳಿ. Learned counsel on both sides to submit their list of authorities. ಯಾವ ಕೊಡ್ತೀರಿ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಡೇಟ್ ಹೇಳ್ಬೇಕು. ನೀವು ಯಾವ ಕೊಡ್ತೀರಿ, ಅದ್ರ 2 ದಿನ ಬಿಟ್ಟು ಹಾಕ್ತೇನೆ ನಾನು.
follow certain conditions.
On both sides to submit their list of authorities on or before Wednesday.
9th.
Other next Monday hearing.
14th.
Good.
Yes.
96 ಸೇಮ್ ಸ್ವಾಮಿ, ಬಟ್ ಅದರಲ್ಲಿ
96 also may be posted along with this. We'll understand.
163. Please.
ಇದು ಅವರು ಮತ್ತೆ ನೀವು ನಿಮ್ಮ ಇದು ಹಾಕಿಬಿಡಿ ಮಹೇಶ್. ಸ್ವಲ್ಪ ನೀವು ಮೇಲ್ ನಲ್ಲಿ ಕಳ್ಸಿದ್ರೆ ಆಯ್ತು, ಒಂದ್ ಸ್ವಲ್ಪ ಇನ್ ಅಡ್ವಾನ್ಸ್, ಆರ್ ಸೆಂಡ್ ಇಟ್ ಟು ಅವರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಹರೀಶ್ ಬಾಬು 96.1 ಇದ್ರಲ್ಲೂ ಅದೇ ಕ್ವಶನ್.
Yes, my lord. I want to distinguish, my lord, what has been.
Okay, you please. ಅಂದ್ರೆ ನೀವು ಡಿಸಿಷನ್ ನಿಮ್ಮ ಪಾಯಿಂಟ್ಸ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬುಲೆಟ್ ಪಾಯಿಂಟ್ ಕೊಟ್ಟು ಕಳಿಸ್ಬಿಡಿ. That helps.
Please.
Idrallu learned counsel on both sides to submit their brief points of arguments in a bullet point manner, and also submit their list of authorities on or before their date. List on the next date. But please don't delay it. Do it immediately.
Please.
Submit it.
95, Madhukar Nadi.
Appearing for the petitioner. My lord, here the case. My name may be shown, my lord. H. Manjunath. I have also signed the Vakalat.
Not 10th.
Mr. Madhukar Nadi is no more appearing in the case, my lord. I am also signed the Vakalat, my lord. My name to be.
ಈಗ ಇವರು ಮಧುಕರ್ ನಾಡಿಗ್ ಸಂಕೇತ್ ಬಿಸಾನಿ ಇಬ್ರು ಅಪೇರ್ ಆಗೋದಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಅವ್ರು ಶಿವಮೊಗ್ಗ ಶಿಫ್ಟ್ ಆಗಿದ್ದಾರೆ.
Learned counsel Shri H. Manjunath submits that Shri Madhukar Nadig and Saket Bisani are not practicing before this court, and their names may be deleted. Hence, delete their names. ಇಲ್ಲಿ ನೋಡಿ, ಕೇವೇಟರಿಗೆ ಮಧುಕರ್ ನಾಡಿಗ್ ಅಂತ ಒಂದೇ ಹೆಸರಿದೆ.
ನನ್ನ ವಕಾಲತ್ತಲ್ಲಿ ನನ್ನ ಸಿಗ್ನೇಚರ್ ಇದೆ.
ಯಾರ್ದು? ಮಂಜುನಾಥ್.
Yes, my lord.
ಇದರಲ್ಲಿ ಕೇವೇಟರ್ ಇಲ್ಲಿ ಮಧುಕರ್ ನಾಡಿಗ್ಸ್ ನೇಮ್ ಟು ಬಿ ಡಿಲೀಟೆಡ್. ಶ್ರೀ H. Manjunath to be shown.
Next week any date?
Krishna Swami. Right, next week.
No obliged.
96 adjourn. 97 N Krishnaswamy.
Yes, apply for the respondent number 4, my lord.
ಈ 2011 and 12 ಇಷ್ಟನ್ನು ಯಾವಾಗ ಶುಕ್ರವಾರ ನಾಳೆ ನೆಕ್ಸ್ಟ್ ಶುಕ್ರವಾರ ಆಯ್ತು. ಇದು ರೆಸ್ಟ್ ಆಫ್ಟರ್ 4 weeks on day 12. 2013 4 weeks, 16 mailing 8 weeks.
Seniority.
Memo for posting.
Memo for posting. See number 111.
My lord, it's a appeal for quantum, my lord, 2012 appeal.
List 14th.
Date my kindly.
14.
112. Sorry, memo for withdrawal.
Right. I filed a memo for withdrawal, my lord. It may be disposed of as withdrawn and the amount in deposit may be transferred to MACT, my lord.
Okay. Learned counsel for the appellant has filed this memo for withdrawal of the appeal. Heard the Mahesh for the appellant. Memo is accepted. Appeal is dismissed as withdrawn. The amount in deposit shall be transmitted to the MACT along records along with the records. Okay. Idu admit.
113.
Admit.
Connected R2 PA idu.
My lord, first case MD appellate, my lord.
Same idare
ಈ
parties.
113.1 ನಲ್ಲಿ
ಅವರು
R1 ಅಂದ್ರೆ ಅವರು ಸುಮಂತ್ ಭಾರದ್ವಾಜ್ ಅವರೇನಾ ಏನು?
ಅದಿನ್ನ ನಾನು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಶ್ರೀ ಸುಮಂತ್ ಎಲ್ ಭಾರದ್ವಾಜ್ is directed to take notice for R1. ಅದು ಕಾಪಿ ಎಲ್ಲ ನೀವು ಇದು ಮಾಡ್ಕೊಳ್ಳಿ ಕೇಳ್ಕೊಂಡು. 2013 ಅಡ್ಮಿಟ್ TCR ಬಂದಿದೆ. TCR ಆಯ್ತು ಅಡ್ಮಿಟ್.
114 finally.
ಇದು ಅಡ್ಮಿಟ್ ಆಗಿದೆ. List for hearing as per seniority. Memo rejected.
115 final hearing.
My lord, I appeal for appellant, my lord.
Memo rejected.
116 admission.
Admit TCR.
117 admission.
Hearing for the appellant, my lord, we have not received compensation.
Memo accepted. Notice to R1 is dispensed with. Admit TCR.
117 Spurti Egde.
Admit TCR. Idea.
118.
Okay. To 117.1. Non-depositing Jay Prakash.
My lord, appearing for the appellant in the connected matter, the insurance company has not deposited.
Deposit ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ನಂದಲ್ಲ, ನಾನು ಕ್ಲೈಮೆಂಟ್ ಅಪಿಯರ್ ಆಗ್ತೀನಿ ಸ್ವಾಮಿ. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು.
ಮಾಡಿದಾರಾ ಇಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಅಮೌಂಟ್ ಇನ್ನ ವಿಡ್ರಾನೆ ಮಾಡಕ್ಕೆ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅಲ್ಲ ಸರಿ, ಈ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರಾ?
ಮಾಡಿಲ್ಲ.
2 weeks time granted. Shri R. Jayaprakash is absent. 2 weeks time granted finally for depositing 60% of the award amount as directed by order dated 2/7/2014. Failure to do so shall result in dismissal of the appeal for non-prosecution without reference to the court.
118 admission. Substitute service.
118 minute paper publication for R1 and R2 minute.
Ordered date LR.
119 admission.
Idu admit TCR.
One submission, see number 119 ಅಲ್ಲಿ R1 steps ಅಂತಿದೆ. I may have to take the steps through paper publication.
ಇದು admit ಆಗಿದೆ?
ಇಲ್ಲ, admission.
Admit TCR. Shri Shripad V. Shastri praised time for taking necessary steps. ಅದು ಯಾವ ಬೇಕಾದ್ರೆ ಅರ್ಜಿ ಹಾಕಿ ಬರ್ತದೆ.
120 delay ಇದೆ.
I am for the respondent.
Notice on IA number 1 of 2018. Lombardi ಯಾರು?
ನೋಟಿಸ್ ಕೊಟ್ಟಿದೆ, ಆಗ್ಲೇ ಸರ್ವ್ ಆಗಿದೆ. ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ.
ನಾವು ಯಾರು? ನಾವು ಲಂಬಾರ್ಡಿಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ,
ICICI. Pradeep is directed to take notice for R2. Learned counsel for the appellant is directed to serve copy of the appeal on Sri B. Pradeep forthwith. Delay our party.
121 PB Sidramaya
admit.
ಇದು ಕನೆಕ್ಟೆಡ್ ಆಗಲೇ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. 122
so IA for 21 for early hearing is rejected for the present.
Malad, I appear for the appellant, Malad. 122.
ಅದು 271 days delay ಇದೆ ಸರ್. 122 ನಲ್ಲಿ
notice TCI
123 disposal ಇದೆ ಸರ್. ಓ ಮಹೇಶ್ 123.
Mr. Mahesh.
123. Oh, Mahesh.
I have moved for IA, my lord, for stay. It has been wrongly, my lord, stay.
Withdraw.
It may be posted day after tomorrow, my lord, for
148 days delay.
Meaning a day after tomorrow anta case. Delay ಇದೆಯಾ?
148 days.
ಯಾವ್ದಲ್ಲಿ? 123. ಇದು 50% ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
ಮಾಡ್ತೀನಿ ಸರ್, ಮಾಡ್ತೀನಿ.
Learned counsel for the appellant submits that he will deposit 50% of the award amount within 4 weeks from today. Issue notice TCR, issue stay as paid for, subject to depositing 50% of the award amount
before MACT.
Before MACT within 4 weeks from today. Liberty reserved to the respondent to seek modification of the interim order on appearance.
Please.
124. Admission.
My lord, in this appeal, my lord, I am going to take notice for respondent, my lord.
I admit TCR. HDFC Irgona.
Yes, my lord.
Shri D. Vijay Kumar is directed to take notice for R2. Shri Rangegowda NR is directed to furnish one set of papers to Shri D. Vijay Kumar.
Much obliged.
Notice to R1 is dispensed with as paid for in the memo.
Please, my lord.
125 Shivareddy KN delay is 142 days.
Notice TCR.
126 BCC
delay ಇದೆಯಾ?
ಇಲ್ಲ ಸರ್, ಅಡ್ಮಿಷನ್.
Admit ಇದರಲ್ಲಿ stay ಇದೆಯಾ? Admit TCR ಇದೆ, delay ಏನಿಲ್ಲ ಅಲ್ಲ?
127 admission.
Appearing for appellant.
Admit.
Ashokan Patil has to file wakalat.
ಹಾಕ್ಬೇಕಲ್ಲ ಅಶೋಕ್ ಪಾಟೀಲ್. ಹಾಕ್ತಾರೆ ಬಿಡಿ, ಅವರಿಗೆ ಹೇಳಿ ಬಿಡಿ ಇನ್ನೊಂದ್ಸಲ.
128 ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ
admission. Notice TCR ಏನು IA ಇದೆಯಾ? On IA number 1 of 2021 issue stay as paid for subject to the appellant depositing 50% of the award amount within 4 weeks from today. Full stop. Liberty reserved to the respondents to seek modification in interim order on appearance.
129 PB Sidramaya admission.
And then trial court record may kindly be called my trial court record may kindly be called my lord.
Right, admit TCR. Admit TCR.
Much obliged.
130 admission.
Admit notice TCR. 131 ditto.
ಇಲ್ಲ ಸರ್, 131 ಅಲ್ಲಿ ಡಿಲೇ ಇದೆ.
Delay ಇದೆಯಾ?
87 days.
Notice TCR. ಇದರಲ್ಲಿ
132 ನಲ್ಲೂ ಡಿಲೇ ಇದೆ.
Notice TCR.
133 ಅದರಲ್ಲೂ ಡಿಲೇ ಇದೆ.
Delay ಇದೆ. Notice TCR.
134 admission.
134 is insurer appeal on liability, please, my lord. 3,49,000 has been awarded. One submission, please, my lord. I will deposit the
Admit
2
notice
lakh.
TCR. Admit notice TCR. ಎಷ್ಟು ಅವಾರ್ಡ್ ಆಗಿದೆ?
3,49,000 ಅವಾರ್ಡ್ ಆಗಿದೆ. ಲಯಬಿಲಿಟಿ ಚಾಲೆಂಜ್ ಮಾಡಿದೀವಿ. I will deposit the 2,50,000 before this honorable court with interest, please, my lord.
ಅಂದ್ರೆ ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
Within 4 weeks, I will deposit before this honorable court, please. Kindly stay the.
ಆಯ್ತು, IA ಎಷ್ಟದು ಸ್ಟೇದು? IA number 2 of 2022 issue stay as paid for, subject to the appellant depositing rupees 2.50 lakhs with the interest with proportionate interest
Before this honorable court, please, my lord.
Within 4 weeks from today before this court.
Please, my lord.
The liberty reserved to the respondents to seek.
ಅಲ್ಲ, ಲಿಬರ್ಟಿ ಲಯಬಿಲಿಟಿ ಇದೆ, ಲಯಬಿಲಿಟಿ ಇರೋದ್ರಿಂದ ನಾನು ಕೇಳ್ತೇನೆ. ಪೇನ್ ರಿಕವರಿ ಆರ್ಡರ್ ಟು ಬಿ ಪಾಸ್ ಆಗ್ಬೇಕಿತ್ತು, ಮಾಡಿಲ್ಲ ಸಾಹೇಬ್ರು, ಕೆಳಗಡೆ ಸಾಹೇಬ್ರು ಇಲ್ಲಿ ಮಾಡ್ಬೇಕು.
ಅಂದ್ರೆ ಮತ್ತೆ ನಿಮಗೆ ಅಷ್ಟೊಂದು ಲಯಬಿಲಿಟಿ ಬಂದೇ ಬರ್ತದಲ್ಲ.
ಅಂದ್ರೆ ಅಲ್ಲಿ ಕ್ವಾಂಟಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
ಲಿಬರ್ಟಿ ಇದ್ದೇ ಇರ್ತದೆ. ಆಯ್ತು.
135.
One sufficient
notice TCR.
My lord, in this case, my lord, EK matter, my lord, I have deposited entire award amount before the MLPT, my lord. 135, my lord, I start stay, my lord.
Last matter.
Yes, Swami.
Learned counsel.
131.
Learned counsel Pradeep alla?
Yes, my lord. Yes, my lord.
Learned counsel for the appellant submits that appellant has already deposited the entire award amount before the learned claims tribunal. Full stop. Issue stay as prayed for.
One submission, please, ma'am.
Your lordships, kindly, one matter is passed over, my lord, serial number 56.
No time now, madam.
Next week.
Serial
number 1, my lord. List 2, serial number 1.
One humble submission.
Admission.
ಎಲ್ಲ next week. 56 ಯಾವ್ದಮ್ಮ?
56 ಇದು ಎಂ ವೆಂಕಟೇಶ್ವರ ರೆಡ್ಡಿ ಬೆಳಗ್ಗೆ.
ಏನದು?
Admission, my lord.
TCR ಬಂದಿದೆಯಾ?
ಇಲ್ಲ, ಅವರು ಕನೆಕ್ಟ್
ಬಂದಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್. ಮಾರ್ನಿಂಗ್ ಯು ಟೋಲ್ಡ್.
ಆಯ್ತು, ಈಗ ಆಗೋದಿಲ್ಲ ಅದು. ಯಾವ ವರ್ಷದ್ದು? 12. ಆಯ್ತು, next week.
Serial 1, list number 2.
Next week.
Entry ಮಾಡ್ರಿ, urgency ಇತ್ತು.
ಆಯ್ತು, ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
ಇಲ್ಲ ಸೋಮೇಶ್, ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಬೇಕಾಯ್ತು. ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್, ಲೀಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಸಾಹೇಬ್ರ ಅಲ್ಲಿ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವಾಗ ಬರ್ಬೋದು ಮೇಡಮ್?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡೋಣ ಸರ್, ಗೊತ್ತಿಲ್ಲ ನಮಗೂ. ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಡೇಟ್ ಯಾವ್ದಾರ ಒಂದು ಕೊಟ್ಟಿರಿ ಮೇಡಮ್, 14 ಇಲ್ಲ ಯಾವ್ದಾರ ಒಂದು.
ಆಯ್ತು ಸರ್, ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಬಿಡಿ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ತೀವಿ.
ಆಯ್ತು ಮೇಡಮ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.